Pass over. Item number 2.
2 Millers, may I please Millers?
May I please your lordship, may I please your lordship,
Millers, item number 2 Millers, petitioner challenges the order dated 27/4/2019. In item number 2, I am in item number 2. Millers challenges the order dated 27/4/2019 under Annexure 4, wherein the Honorable Commission has given employment Millers to the married daughter's husband and sons who was minor on the cut-off date. Same issue was heard by the Honorable Supreme Court Millers on 17/11/2021 Millers, and judgment has been reserved Millers. So therefore, I pray that matter may be taken up to. In the meantime, judgment will come out. Millers.
As a request of Mr. Devraj Mohanty, consider the list on 5th January.
I'll oblige you.
Mr. Das, are you there? Mr. Shakti?
Yes, I am there.
Please come. Yes.
It was not reopening. Millers, may I please your lordship?
Yes.
Millers, Mahanadi Coalfield is the appellant in the writ appeal. The facts are like this, Millers. One, Mr. Suresh Saha, fraudulent.
We were unable to find this 10th August order which you are challenging. Where is it?
Yes, Millers, it is the last page. It is at the last, Millers. Page mark behind.
After 106, page 106.
After page 106. Why did you not page mark? Ye to te pata padhi. Page 100, after 106 Millers, return.
All right. What is the point here, sir?
Miller's point is a person who has impersonated himself as son of one Gangar Saha got appointed in SCCL in the year 1984. SCCL merged with Mahanadi Coalfield in 1997. Thereafter, 92, 2000 it merged. Thereafter, Gangar Saha made a complaint to the Mahanadi Coalfield that this fellow is not my son. He has fraudulently got himself as the son of my husband or myself. So the inquiry was done. If your lordship could kindly turn to page 103 Millers, your lordship may kindly turn to page 103. Your lordship will kindly see that letter, page 103. Am I permitted to place that?
Yes, yes.
Yes, please. We have received a complaint by one Belamati Saha, wife of Gangraj Saha, village so and so, district. Srimati Belamati Saha claims that she is issueless and that you have managed to got employment in MCL as son of Sri Gangraj Saha, whose land has acquired at MCL for mining of coal at village Darlipali by falsely representing yourself as son of Sri Gangraj Saha.
All right. We'll issue notice. Anyone appearing on the other side? All right. You just say notice. Make it returnable by the next date. You say list on 9th February. Till the next date of hearing, the influent judge.
Obliged.
Item number 3.
My pleasure, lordship. The petitioner, if your lordship, is a street vendor, Millers, and a survey was conducted under section 3 of the Street Vendors Act, and identity card and certificate was issued, your lordship. And Millers, page 10 and page 11 are the identity card and the vending certificate. Now, the grievance of the petitioner, if your lordship, is that the municipality, without following due procedure, as contemplated under the Act, Millers, is going to evict the petitioner.
So, this going to, we're not able to understand. What is the, on what basis they are saying that you're going to?
They have made loudspeaker announcement, your lordship, to that.
No, you filed this on 23rd August 2021.
Millers.
So 3 months have passed.
Millers.
If they were going to evict, by now they used to have been evicted.
They have not evicted, Millers. But
so which means we don't know if what you said in the writ petition is correct at all or not.
Plus, they have to that effect what they are doing, Lord. They are making loudspeaker announcement. Thereafter, they are coming and plus demolishing the structure, Lord.
Sir, you filed this on 23rd August.
Plus, till that, plus my information is that till that they have not taken any step, Lord. But usually they are making loudspeaker announcement, and after that, any date they are coming and demolishing without following.
Do not even say all that loudspeaker announcement. Nothing you are saying here.
Milords,
come to para 14. Where have you said they're coming to make they're making loudspeaker announcement?
Plus, para 5 I have stated, your lordship. Para 5 lords. Page 4.
No, again, no dates. You're not giving any dates.
Plus, date I have not mentioned, but they have made the loudspeaker.
So we should ourselves imagine the dates, sir.
That I have not mentioned, my lords.
When will you mention, sir?
Usually,
So you file a proper petition. You see, when you file 226, you have to give complete facts. You have to give facts, the dates, the time. You have to do all that. Counsel, the petitioner seeks leave to withdraw this petition with liberty to file a better petition.
Item 28 is similar, I think.
28 notice has been issued. Your lordship directed to take instruction, lords.
Okay, it will.
All right, let's see when it comes to.
Item number 4. I filed the counter affidavit, my lord.
It's not come on record, I think.
My lord, the hard copies are with me. I can provide.
Please. You not even issued notice in this. You already filed
No,
counter.
your lordship has directed that only to file a small affidavit whether what is the progress in the election process. I have annexed all the documents and the series of developments in this matter. Substantially progressed we have. And even your lordship will find we have filed annexures. The notification has already been made for appointment of polling agents.
So it's already underway, Mr. Dalai.
No, Lordship. In fact, Lordship may permit to place
Have a copy
Lordship.
of this counter.
Lordship, I have received counter. I'm ready with reply also, Lordship.
I have instruction
Lordship, kindly-
on behalf of the Election Commission.
Yes.
What they have filed the affidavit, that is also, we have already made a notification under Rule 5.3. In fact, that was over on 23/11/2021, Rule 5.5 of the Panchayat rules. That the notification has made, objection has been invited. And in fact, your lordship said that the process is already underway. The process is substantially underway.
Right.
That is, people also will say, I'll file that affidavit because the notice had not been issued. I thought it would not be proper for me to file an affidavit, but the state council.
Let us hear Mr. Dalai.
Lordship. Lordship, they have served on me the copy of the reply held by the state authorities, Lordship, that is the Undersecretary to the Government Panchayat Department, stating therein, answering Lordship's query, they are saying the election process has already been started, my lord. That much I can answer, Lordship, because Lordship specifically had queried last occasion whether by this time election process already started or not, Lordship. And Lordship kindly see, there are 3 provisions in the Constitution which puts embargo on the court, Lordship. During the election process, the court should not interfere in this matter, Lordship. The 3 provisions, Lordship, 329 of Constitution of India, and so far the present part is concerned, it Article 243O and Article 243ZG, Lordship. It is coming on municipal act. Now the present context, Lordship, can be Article 243O because it's 3-tier Panchayat Raj election. Bring Lordship Article 243O for a moment.
Yes.
Bar to interference of courts in electoral matters, notwithstanding anything in this constitution, the validity of any law relating to the delimitation of constituencies or the allotment of seats to such constituencies made or purporting to made under Article 243K shall not be called in question in any court. But no election to the Panchayat shall be called in question except by an election petition present by such authority and in such manner as is provided for by or order under law made by the legislature of a state. Lordship, kindly see what is my grievance, Lordship. I am in fact not challenging any of the law, the prevailing now, Lordship. Lordship, kindly see Annexure 1. For a moment, Lordship, I am not challenging. But here in Lordship, that is running past 28 Lordship. But it is a circular issued by the opposite partner of Panchayat Raj Department, which has reversed the entire constitutional mandates, constitutional provisions, and the provisions which has been enacted by the state government as per the 7th Amendment of the Constitution of India. Lordship, just a kindly to running past 29. Only I am challenging clause 2 and 3, Lordship. Though there are other lacunas, for present context 2 and 3 is Lordship and challenge. Lordship, kindly see page 2, 29. Population percentage of scheduled caste tribe, people in the respective GP, block, district according to 2011 census would be the determining factor for the computation of number of seats offices to be reserved for SC or ST category and 3 PRS, Lordship. Then, Lordship, the second provision, Lordship, while determining the reservation status of various seats offices of PRS for general election to the PRS 2022, the principle of rotation descending order shall be followed, taking into account the reservation of status of last PR elections held in 2002, 7, 12, and 2017. Yes. They have given 2 directions which is been adhered by all the collectors while finally the reservation list, Lordship. What they have done, Lordship, they have said to take the population of SCST so far the local area is concerned, GP, black and district, Lordship. And so they have adopted the principle of rotation in descending manner since 2002. These 2 of the clause I have serious objection, Lordship. Then, Lordship, kindly see Orissa Gram Panchayat.
The test is very simple.
Lordship.
Suppose we were to allow your prayers,
Lordship.
will it affect the outcome of the election?
No, Lordship.
Of course it will.
No, Lordship. Lordship, I can, because I am relying on the, I am relying on Lordship.
The whole principle of reservation is under challenge by you, correct? You're challenging the manner of making reservations for these seats, correct?
Lordship.
So if your writ petition is allowed,
Lordship,
with the notification already having been issued,
Lordship,
will it not affect the outcome of the election?
No.
I don't agree with you on that at all.
I'm relying
You're just deliberate. You're not even thinking for a minute, and you're simply answering.
He's saying no. It will directly affect.
Lordship, may I explain?
You're desperate that we should make a writ petition. So irrespective of the factual situation, you're simply saying no.
Lordship, I'm relying on a recent judgment of this honorable court regarding this fact, Lordship. This facts, Lordship. This squarely cover my case, and this fact has been tested by honorable apex court, Lordship. Kindly see, Lordship. Here, Lordship, the judgment, Lordship, starts from page 10. A very similar case. It is the question related to the municipal election in the state of Goa. After election notification, Lordship, the enter the reservation was under challenge, and the very same writ petition was allowed by Honorable High Court. Then it was gone to Honorable Apex Court. And Lordship, kindly see just a minute, the findings of the Honorable Court at page 94, Lordship, para 63. Lordship, page 94, running page 63, Lordship, and internal page 84, Lordship. May I place this judgment, Lordship?
Yes.
Lordship. A constructions of the aforesaid judgments in the context of municipal elections would yield the following results. Under Article 243 ZGB, no election to any municipality can be called in question except by an election petition presented to a tribunal as is provided by the under any law made by the legislature of a state. This would mean that from the date of notification of the election till the date of the declaration of result of a judicial hands-off is mandated by the non-obstinate clause contained in Article 243 ZG, debarring the writ court under Articles 226-27 from interfering once the election process has begun until it is over. The constitutional bar during this period, let's see, this is important, let's see. It is therefore a matter of discretion exercisable by a writ court as to whether an interference is called for when the electoral process is imminent, that is, notification for election is yet to be announced. But here is no election notification. Then let's see kindly clause 2. Now, letter my submission, it is yet to be conducted after December 25th, that is your own admission, Lordship. After 25th December, they will come up with the election notification. And Lordship kindly see they have annexed some documents, none of other election notifications, only that are orders of the election commission. It is a routine work of the election commission, the state government throughout the year, Lordship. It can be, it could have been done previous year, it could have been day before last year also, Lordship. From the day one, it could have been done, but they have done it at the belated stage, at the only the doorstep of the election, facing the election. Then, Lordship, kindly see, everything is explained in this judgment, Lordship. If, however, a assistance of a writ court is required in subserving the progress of the election and facilitating its completion, the writ court may issue orders provided that election process once begun cannot be postponed or protected in any manner. The non-obstant clause contained in Article 43G does not operate as a bar after the election tribunal dispute before it. Thus, the jurisdiction of the High Court under Article 227 and the Supreme Court under Article 136 of the Constitution of India is not affected as the non-obstant clause in Article 243ZG operates only during process of election. Then, under Article 243ZA, the SC State Election Commission is in overall charge of the superintendent, direction and control of the preparation of the electoral rolls and the conduct of municipal elections. If there is a constitutional or statutory infraction, let's see here I'm speaking of constitutional and statutory infraction by any authority, including the state government, either before, during the process, election process, the SEC by virtue of its power under Article 243ZA1 can set right such infraction, Lordship. For this purpose, it can direct the state government or other authority to follow the constitution or legislative enactment or direct such authority to correct an order which infects the constitutional or statutory mandate for this purpose. It can also approach a writ court to issue necessary directions in this behalf. It is entirely up to the State Election Commission to set the election process in motion, or in cases where a constitutional or statutory provision not followed or infected, to postpone the election process until such illegal action is remedied. The State Election Commission do taking into account the constitutional mandate of holding elections before the term of municipality or municipal council is over. In extraordinary cases, the SEC may conduct elections after such term is over only for good reason. Judicial review of a state commission's order is available on grounds of review of administrative orders. Here again, the writ court must adopt a hands-up policy, file the election procedure on, and interfere either before the process commences or after such process is completed, unless interfering with such observes and facilitates the progress of the election. Then page 97. Article 240Z2 makes it very clear the law made by the legislature of the state making provision with respect to matters relating to or in connection with election to municipalities is subject to the provisions of Constitution and particular Article 243T, which deals with the reservations. Here Article 240D. Let's see. Parameter.
You want to read para 66?
Let's see.
Page 90.
Let's see. Let's see. Para 66. Let's see. However, on the factual aspects of this,
no. Just don't be in so much of a hurry. Don't read it wrongly.
Let's
read it again. Read it again.
However, on the peculiar facts.
Yes.
You missed the word peculiar.
Let's see. I will explain. Let's see. Not peculiar. It's a very similar case. Let's see. They are also.
Those facts are peculiar. Don't now. Supreme Court has said the facts there are peculiar. Don't change that.
I'm reading.
Those facts were peculiar, so I'm just drawing your attention to those peculiar.
I will show Lordship how it is also peculiar, Lordship. However, on the peculiar facts of these cases, this court is constrained not to interfere with the imposed judgment under Article 136 Constitution of India. This is because of the following special features of the facts of these cases. Lordship kind of how they have passed the entire election procedure and they postpone. Here and they have come up with new notification.
Sir, are you in so much a hurry that you don't want to read? If you don't want to read, we don't want to trouble you.
Sorry, Lordship. Lordship, foremost, it is important note that State Election Commission is none other than the Law Secretary to the Government of Goa.
So you stop here.
Lordship.
What is the position here?
Lordship, first provision, Law Secretary is appointed at the Election Commission.
No. We are not asking about Orissa. What is the position here in Orissa?
Here position, Lordship, just Lordship, people allow me to fax only provision of law, then Lordship will
Why
clarify.
don't you give us a factual position, sir? Here is the law secretary, the election commission.
No, Miller.
Okay.
Lordship.
All right. So those peculiar facts are not here, correct? That peculiar fact which the Supreme Court is pointing out is not here.
But there, Miller, Lordship, I'm coming to next paragraph.
You come.
Yes,
Now, okay.
The whole process of these elections is therefore halted at the start to speak. The said election is not in the facts of these cases an independent body as is mandated by Article 243K.
Yes.
Then it is important to please don't. It is not important to note that the State Election Commissioner had itself postponed the municipal elections twice due to the COVID-19 pandemic ragging throughout the state. On the second occasion, by the notification dated 14/1/2021, the SC said itself postponed these elections till April 2021 or the election date which may be determined by the State Election Commission. Obviously, the expression of the election date which may be determined by the Commission would indicate a date beyond April 2021, give the situation in which the state of Goa finds itself due to the COVID-19 pandemic. It is important to note that High Court in its direction contained in paragraph 81E directs the State Election Commission to act in accordance with the notification so that elections are held by 15/4/2021.
This peculiar fact also is not present in our case.
Lordship, I'm coming to that. I'm coming to that, Lordship. I'll come to that, Lordship. I can, Lordship, I will convince you, Lordship, because what they have done, it is not permissible. I am, Lordship, kindly consider my case. Lordship, kindly consider my prayer.
No.
I am not here to solve the election process.
Come to the third peculiar fact.
Lordship. In that, sir, Nasru Naik's case, Supra, and Sujya Luthiker's case, Solomon assurance were made by the Advocate General that orders of reservation in wards of the municipal councils will be made at least 3 weeks before the election program is announced. This is very important, Lordship. The state government, instead of acting upon these statements, inserted an amendment by adding a provision of Section 10 of the Goa Municipal Act, in which a lesser period was mentioned, a period of at least 1 week. Lordship, here, Lordship, I will show Lordship what they have done.
Do these facts exist in our case?
Lordship, no, Lordship, I'll come to that, Lordship. I'll explain, Lordship.
Whenever I ask you, you say I will come to that.
Lordship,
All right. Whenever you come to that, come to the fourth.
Lordship. The Law Secretary later dated 5/2021, calling upon the Director of Urban Development to issue a reservation order under Section 10 of the Goa Municipal Act, was to do so at the Director by an order passed on day before this communication, that is on 4/2021, with lightning speed provided for reservation in all 11 municipal councils of women, SSTs, and OBCs, prompting the High Court to observe that due to application of mine could not have been bestowed before issuing such an order.
So is this fact also present in
Yes,
our
Lordship.
case?
All the reads,
Is this fact present in our case, sir?
Lordship, this fact is not available to this case, Lordship.
Now come to the next.
Lordship, all the writ petitions in the present case were filed between 9th and 12th February 2021, immediately challenging the Director's order dated 4/2021. None of the writ petitions contained a prayer that would hold up any election program. The only prayer was to strike down the aforesaid order so that Director, in issuing fresh order, would have it to truly and faithfully carry out the constitutional mandates of Article 243T of the Constitution, India, and the statutory mandate contained in Section 9 of the Goa Municipal Act. This is my case, Lordship. This is my case, Lordship. When the High Court issued notice on 15/2021 for final hearing up on 22/2021, the State Election Commission did not inform the High Court that is why a note of 5 disclosed for the first time by an affidavit filed in the court on 8/21. Elections were proposed to be held on 23/21. The stage is not come, Lordship. In a clear attempt of which the High Court, the State Election Commission, who is none of the Law Secretary of the State Goa, issues an election notification at 9 AM on 22/21, even before the government offices were opened offices open at 9:30 AM in order to forestall the hearing of
So
the
none of these facts are present in our case. That's why the Supreme Court refused to interfere with the High Court order. Otherwise, this law is absolutely clear, sir.
Here Miller accepted High Court
The
order.
law is absolutely, these are such peculiar facts. which
Here
don't exist in
Miller
this case.
Supreme Court accepted the entire rejection of the Goa Municipal Corporation lordship. And lordship kindly come to last other two clauses. They have allowed the writ petition.
Yes.
After the judgment was pronounced by the division bench of High Court on 1/3/21 and no stay granted, this court issued notice on 4/21 and stayed the impugned judgment, the effect of which was to revive the election program that was notified on 22/21. Despite this, the State Election Commission on this day, that is on 4/21, amended the aforesaid notification by extending the time period for filing of nomination municipal corporations from 4/21 to till such and such period, lordship.
Correct.
Then given the aforesaid order of High Court contained in paragraph 81 of the impugned judgment, will be observed that two changes in paragraph 81C. It is clarified that the period of 10 days in which the Director Urban Development is to issue a fresh order will be 10 days from the date of this judgment. Also, instead of 15 April occurring in paragraph 81E, the word 30th April be substituted. All the other directions will remain undisturbed. The most disturbing feature of the lordship, this is very important, lordship, 68. The most disturbing feature of these cases is the subversion of the constitutional mandates contained in Article 243K, the Constitution of India. The State Election Commissioner has to be a person who is independent of the state government, as he is an important constitutional functionary, which is oversee the entire election process in the state, panchayats and municipalities. The importance given to the independence of the State Election Commission is explicit from the provision from the removal of his office made in the proviso to clause 2 of Article 243K, insofar as manner and ground for his removal of the office is concerned. He has been equated with a judge of high, giving an additional charge of such an important and independent constitutional office to an officer who is directly under the control of the state government is, in our view, a mockery of constitutional mandates. We therefore declare that additional charge given to a law secretary to the government of the state flouts the constitutional mandate of Article 243K. The state government is directed to remedy this position by appointing an independent person to the State Election Commission at the list. Such person cannot be a person who holds any office of the post in the central or state government. It is also made clear that henceforth all the State Election Commissions appointed under Article 43K.
Don't go on reading that. That is not relevant for our case at all. You yourself say that point does not arise in the present case.
Lordship, then to the finding, last conclusion, para 69, lordship.
Sir, all these peculiar facts, not one fact
Yes,
is present in the present
I am answering the peculiar facts, lordship. Lordship, what lordship, kindly consider my grievance, lordship. What I am trying to put forth before lordship. Can an officer of the state, will they change the constitution? Can they amend the entire statute, lordship? I am not against election process. I am not against the process of election. But my humble sums, lordship. Kindly see what authority, lordship, kindly the section 9 of the OGP Act. What power vested with the Election Commission, lordship, section 9 of the OGP Act for movement, lordship. Orissa Gram Panchayat Act, lordship. Lordship, powers of Election Commission and the electoral rolls of wards. The superintendent's direction and control of the preparation of electoral rolls for and conduct of all elections to the Gram Panchayat shall be vested in the Election Commission. Lordship, there are three parts, lordship. Lordship, can be categorical. Superintendent is always there, lordship. DC direction and control of preparation of electoral rolls. Not it has to be completed fast. Then lordship, then go for election, lordship. Then the lordship kindly come to election rules section, rule 13, lordship, for a moment. What is a Gram Panchayat election rules 1995, rule 13, lordship.
Yes.
The order under section 12 shall be issued. This is the final publication resolution, lordship, they are saying. Issued on such dates as may be recommended and immediately after it is issued, the commissioner shall draw of and notify the program of election in such manner that as per the practicable, the election in all the wards of the gram, including the election for the office of the sarpanch, be conducted on and the same day and communicate the program to the election officials. Then Lordship, can you their counter? They have come up their counter. Lordship, page, the internal page 8, Lordship, their counter, Lordship.
Yes.
Lordship, they have given 3 dates, Lordship. In first paragraph, and column 1 to 3, the last is the election. And then whereas, Lordship, whereas it is necessary to hold election to the Panchayat Raj institutions before 10/3/22, 11/3/22, 12/3/22. It is 3 months left to conduct the election. Then, Lordship, kindly see page 11, Lordship. Page 11, the schedule 1. They have given these and all of the orders. There is not election notification. They have not come up with the election date of election notification. Then schedule 1, Lordship, page 11. I'm relying on last line, Lordship. Printed copy of commission. The final electoral list will be produced before commission on 14/12/2021. The next month, 14th, they will prepare the final election. Yet to the election notification has to come. Then Lordship, kindly come to only 2 provisions of law, Lordship. That is Orissa section 10(5)(a) of the Gram Panchayat Act, Lordship. 10(5)(a). Page 10, Lordship, the page 35, Lordship, holding the same book, Lordship, publication. Page 35.
Yes, please.
Lordship, notwithstanding anything to the contrary in this section, the offices of sarpanchas in the Gram Panchayat shall be reserved for the scheduled caste and scheduled tribes. And the number of offices so reserved for the scheduled caste and scheduled tribes shall bear as nearly as may be the same proportion to the total number of such offices as the population of the scheduled caste and scheduled tribes respectively in the state bears to the total population of the state. This is the after Article 243, Lordship, after 7th Amendment, they have enacted the law and they have enacted the law how the reservation will be considered. So far the SC is concerned, and the Lordship, kindly see the notification of what they have done. The statute says the entire population of the state has to be considered. But the secretary has given direction to all collectors. No, you don't go with the statute. I am creating a new law. You go the population as per the local blocks, panchayats, and the district is concerned. The first violation. Then Lordship, kindly this 10(6)(a) for 10(6)(a), Lordship. Lordship, next page, Lordship. For the purpose of reservation of offices, sarpanchas in the Gram Panchayats and subject to the provisions of section 5, (a), the Gram Panchayats in relation to grams in which the density of population of the scheduled caste and the scheduled tribes is higher in the block shall be reserved by the collector for the scheduled caste and scheduled tribe respectively and shall rotate in descending order after every 2 terms general election. Lordship, kindly see that this statute amended after 7th Amendment, and the state government came up with the enactment in the year 1994. After 94, Lordship, they came up with the first election in 1997. 97, the principle adopted. Since 1997, the principle of rotation descending order started since 1997, Lordship. It already existed. But the secretary, what did, Lordship, kindly see the second clause. Clause 3. While determining the reservation of status, offices, PRS for general election to the PRS 2022, the principle of rotation descending order shall be followed, taking into account the reservation status of the last PRA elections held in the 2, 7, 12, and 17. Here they had changed the entire constitutional mandates, he's changed the statutory provisions. And Lordship, I have shown Lordship the power of the State Election Commission. Only direction can be given by the State Election Commission. But here, the secretary came up with a notification. And directed.
Mr. Rautre, what were you saying? State Election Commission?
First of all, I have not been served with a copy of the writ application. I don't know what is his prayer. But since your Lordship last time directed the State Council to take instruction, therefore, whatever instruction I have got, the notification under Rule 5.1 of the Gram Panchayat rule, in fact, that was fixed to 15/11/2021. Then Rule 5.3 also looked to Rule 5.
No, what is being challenged are the guidelines for reservation to the offices of PRI members. The 1/10/2021 order that has been challenged in the present petition. That's the main challenge.
Let him serve a copy so that I can take instruction from the commission.
All right. An affidavit has been filed by the Undersecretary to the Government, Panchayati Raj and Drinking Water, enclosing the orders issued on 8th, 15th and 16th November 2021 by the State Election Commission regarding preparation of electoral rolls and general instructions regarding appointment of counting agents, holding of polling, and orders concerning expenditure to be met by a candidate contesting for the posts of member Zilla Parishad and member Panchayati Samiti and Sarpanch. Paragraph. Mr. Dalai, Learned Counsel opinion of the petitioner, submits that in terms of the proposed time schedule, it is only the preparation of electoral rolls that is to be completed by 14th December 2021, and that the time for holding elections where are the three time limits you were pointing out?
Yes.
March 21.
Yes.
In terms of the order dated 8/11/2021 would be before for Gram Panchayats, Panchayat Samitis and Zilla Parishads would be 10th March 2022, 11th March 2022 and 12th March 2022 respectively. Reliance is also placed on the decision of the Supreme Court of India dated 12th March 2021 in civil appeal number 881 of 2021, bracket State of Goa versus Fauzia Imtiaz Sheikh, to contend that since the election schedule is yet to be announced, there is no constitutional bar to Section 2, Article 243 of the Constitution of India, with this court entertaining the present writ petition, which challenges a notification dated 1st October 2021, issued by the State Election Commission, announcing guidelines for reservation to the offices of the Panchayat Raj Institution, bracket PRI, members for the general elections to the PRI 2022. See, Mr. Buddhadev Rathri, a senior counsel appearing to the State Election Commission on advance notice, states that he may be served a copy of the petition so that he can seek the instructions of the SEC specific to the prayers made in the present petition. A copy there of the petition be served on him today itself. Full stop. The SEC will file an affidavit specific to the issue raised in the petition. Paragraph, the court makes it clear that it has not yet expressed any view regarding the maintainability of the present petition and permits the parties to make their arguments in that regard on the next date. List on.
So, Your Lordship, keep it to
20th December 2021.
Lordship, any decision, Lordship, any decision in the meantime, Lordship.
No. We're not passing any interim order. We're not even satisfied about the maintainability. That's why in the next state we hear full-fledged arguments on maintainability.
My lord, our affidavit.
Because Lordship, they have prepared
We have
the
already said that. The order has started only with your affidavit.
Lordship only, my Lordship, because they have fixed 14/12 for the law.
Completion of
preparation.
electoral rolls. That's the completion of electoral rolls.
Just before that can be listed.
Why should it? It need not.
So that it can be disposed of. My grievance is not against any.
We are not
to solve
at
the
all
process.
satisfied, sir, about maintainability yet, because none of the peculiar features pointed out was case. But we still want to hear their arguments. After you serve them, copy the petition.
Lordship, oblige, Lordship.
Item number 5.
Lordship, can it be in fresh admission, Lordship? On this?
Whatever, it will come on that date.
Even if it is after notice, it will reach.
All right. The office note has been produced. The permission is granted for reconstruction of the first.
Item number 6.
Please, Your Lordship. The offence is under section 302 and the conviction for life malord and to pay fine up to 10,000 rupees in default to go for RI 1 year malord. The petition appellant is in custody since the 2010 September malord.
No. Right now, the appeal is listed for hearing.
No malord, it is for bail.
Bail application is a 2013 application, sir.
Yes, malord.
The facts have changed in the last 8 years. So much must have happened.
No malord, because he is in custody.
No, we might as well hear the appeal. Then the paper books are ready.
No malord, paper books are not ready.
No, if the depositions are there, you can argue.
Yes, but cleansing certain.
There is no eyewitness to it, malord. And it will take some time to prepare for the final argument malord. So it is only for I am placing for the bail malord.
No. At 2013, without any new application, new affidavit, there's no facts.
No, malord. No new appeal.
Paragraph 8 and 9 of the judgment you lost me calculate.
No, but anyway, he has to argue the appeal.
Man,
But date may be fixed, malord. Then the date may be fixed for argument.
All right. List for final argument on 19 January.
item number 7.
May I please, Your Lordship?
Number 8, Your Lordship. Mr. Pitambar Acharya is traveling for some personal exigency, Lordship. May I pray for any day after Tuesday?
Concern, my lord, item number 7, your lordship has directed that each of the appellants, I am in the other appeal, connected appeal, my lord, he covers the same.
Lordship, item number 8, Your Lordship. Mr. Pitambar Acharya is traveling, Your Lordship, for some personal exigency. May I pray for any day after Tuesday, Lordship?
May I make a prayer, beloved, in this appearing for respond number 4? In fact, I am not on the opposing the adjournment. I had made an application for a variation of stay. Will your lordship direct in month of say February for disposal because the stay is operating for last 15 years in different before the single judge, now before your in the division bench. So lordship, you can direct for a date for disposal because 15 years stay is operating for not
All
taking
right.
any.
Mr. Pidambar Acharya, Lord Senior Counsel for the appellate, is stated to be in some personal difficulty today. There is a stay order operating against the respondents. Considering these facts, it is directed that the present appeal be listed for hearing 23rd February.
Grateful to your lordships.
Deeply obliged, Your Lordship.
Your lordship,
Item 9.
interim order, their interim orders may continue.
Interim order continue, Your Lordship.
Yeah, interim order.
Grateful to you.
Deeply obliged, Your Lordship.
Item number 9.
My lord, may I permitted to be withdraw with
All right,
liberty to
counsel
approach the
petitioner seeks
authority.
leave to withdraw the present petition with liberty to file a fresh petition if any cause of action survives.
To approach the authority, my lord, with permission to approach the authority, my lord.
Oh, with permission to approach the authorities for appropriate reliefs, dismiss is withdrawn with liberty is paid.
Item 4.
Defects,
Item 14, my lord. Lordship may kindly give 2 weeks time to remove the
list of removal of defects.
Item number 15.
No, 2 weeks time for removal of the defects.
Yeah, list of removal.
Item
Published.
number 16. Item number 16.
Dismiss no. Somebody should appear, or we'll just pass it over once.
Item number 17.
I may be permitted to withdraw, my lord.
Or counsel petition that memo is taken on record. Dismiss is withdrawn.
Item number 18.
May I please, Your Lordship?
Defects,
Order.
remove the defects.
My lord.
List of removal of defects.
Item number 19.
My lord, 18.
Item number 19.
Mr. Pari, we have said list after removal of defects.
Obligement.
19. I think what we'll do is we'll just come back in 10 minutes.
Item 19.
Wait, please.
Yes, please. It's
I-
good to see you.
I respectfully demask myself before my lords, so that there is no suppression. Now, my lord, this is an interesting matter.
Yes.
But an overview of the matter is this, my lord, that
Yes.
when a man, my lords, who has not disclosed his complete income comes before a settlement commission, then he has to come clean. And the legal postulation is, my lords, that when you so enter the sanctified tunnel of chapter 19 of the Income Tax Act, which begins from section 245 capital C, right up till 248, then, my lords, the legislative intent, my lords, proscribes that there be no bargain in between. Namely, my lord, that supposing I have a income tax, a further liability of 500 crores. I disclose, my lords, 200 crores. It can't be that there is some sort of a settlement in between and I, my lords, get off by paying 250, 50 more or 100 more. The liability may be 500 or the other way around So both ways, my lord, so that the revenue also doesn't, my lords, act and the assessee also doesn't act in a row. So therefore, there is a 3-step filter of 245C. And once you enter that, there are, my lords, 2 occasions under 245D that it goes through a settlement commission report, preliminary report, and then a Rule 9 report. Now, then you have to adjudicate on a Rule 9 report. Now, my lords, none of this has been done. What has been done is they say, and this was done in one golden hearing of 10 minutes, decided 35 issues in about 70, 80 pages, all in a hearing that lasted for 10 minutes, based upon a letter which says that because your counsel said that you are now willing to pay 120 or 145 crores, whatever it is. So therefore, this is the ceiling benchmark. That being the ceiling benchmark, now we will apportion 145 into various heads. So basically, they decide, my lords, 5 heads with no reasoned order, with no submission noted from my side, just this, that this is what it is, this is what they have said, though not in the reply, and this is what we find, so that it meets the 145 ceiling. This, my lords, is the matrix. I'll just take your lordship through a short list of admitted dates, my lords. Your lordships may have the short rejoinder at page 1054. The lordships may get, my lord, just 5-6 dates, and then I'll straight away, my lords, come to the law. Lords, at 1055, (1055) 29th July, I filed, my lords, a 245C, disclosing an additional income of 126 crores. I pay tax of 39 crores and interest I pay 29 crores. This is, my lords, from pages 185 to 627. On the 9th of August, while adjudicating the petitioner's application under 245C, the opposite party, which I, my lords, failed to see here, even virtually, passed an order on the 9th of August, allowing the petition to be proceeded with. Then, my lord, on 29/8/2060, this order was passed, and my application was declared by a quasi-judicial application of mine to be not invalid. In accordance with 245D(3)(2), in case the principal commissioner fails to furnish the report within 90 days, the settlement commission may proceed to pass an order under section 4 of 245D without the report. But they have passed the order on this report, which came belatedly after the statutory period. Yes. And there is no, my lords, extension of time provided in the statute. After 45 days from the expiry of the Rule 9 statutory period report, which expires on so-and-so, we filed the 9 report on 10/2/2017.
One minute, Mr. Sharma, just a minute. Yes. Council, just ask him because the page number, he gave it on his own because we don't seem to have those page numbers here.
Why seem not? But this may create a bit of a problem.
No. We have the affidavit, there's no difficulty. Only the page number.
The 12th of March 2018.
Correct.
At page 1055. Lords, if it's not
12th March is fine. Only the page numbers. So we'll anyway. Yeah. No problem. Stand somewhere.
Lords, if there is a if there is no synchronity, my lords, then we
no
because there's going to be a quite some movement my lords, from file A to file B to file C.
No, we have it. What about you, Mr. Chimanka? You have it?
He has filed list of judgment, I say.
No, sir. This is the rejoinder, page 1055.
It's a short rejoinder.
Have it?
No. I have not received the rejoinder.
I'm reading from, if you don't have the rejoinder, we can supply you the rejoinder.
No. Ask Mr. Marpat.
Omelets, one thing could be that I could attempt to conclude today.
Yes.
Then my friend could look at my rejoinder and then on the next date he could respond.
Correct. This is part 5. It says part 5 of the file. When you go down, explain to them how to scan each part, label it here. You can carry it.
Well. To be a bit unfair to the revenue, I'll nonetheless start. So, my lord, the point in issue is, if your lordships have, my lords, 1055.
Correct.
Now, my lords, your lordships may also see 245C.
Yes, income tax.
Lord, your lordships will be laying down the law in this authoritatively. Because a lot of things happen in the settlement commission for all times, lords, this way or that way, it has to be my lord's rule. Though there is a Supreme Court judgment, Ajmera, but my lord, something more has to be said.
Yes.
Your lordship sees my lord's 245C.
Yes.
Application for settlement of cases. An assessee may, at the stage of a case relating to him, make an application in such form and in such manner as may be prescribed, and containing a full and true disclosure of his income, which has not been disclosed before the assessing officer, the manner in which the income has been derived, additional amount of income tax payable on such income, and such other particulars as may be prescribed to the settlement commission to have the case settled, and any such application shall be disposed of in the manner hereinafter provided that no such application shall be made unless in a case where the proceedings for assessment or reassessment or any of the assessment years referred to in so and so, in case of a person referred to in such, the additional amount of income tax payable on the income disclosed in the application exceeds 50 lakhs, so and so, so and so forth. Well, the essential ingredients would be number one, that it has to be made in a form and in a manner as is prescribed. Now, the prescription, my lords, is contained in Rule 44C1, which also, my lords, I have extracted for your lordships ready reference at Rule 44C1. Lords, apart from the rule, my lords, it has to be verified like an affidavit. That form of verification is in form 34 capital B, which your lordships will probably find, my lords, at page 1062 of the rejoinder. That verification is here, my lord. It is just pari in materia with an affidavit that is sworn under order 6. Internal page 9. Which would be, my lords, internal page 9 of the rejoinder. Sir, aapke paas, this may not be there, but I'll have it supplied.
Verification. Yes, yes.
So, my lord, the thing that which comes forth is this.
Yes.
That if the statute following Nazir Ali says that it has to be done in a particular manner with a verification and in the manner, then it is entering into a quasi-judicial. You can't play with it. I can't play with it. You can't play with it. Then, my lord, your lordships will see this has been filed under 245C. I make a disclosure of 126 crores. I pay a tax of 39 crores and an interest of 29 crores. Now, my lords, upon the receipt of the 245C application, then your lordships may have 245D1. This is the procedure on the receipt of a 245C application.
Yes.
Lords, on the receipt of an application under 245 capital C, the Settlement Commission shall within 7 days from the date of the receipt of the application issue a notice to the applicant requiring him to explain as to why the application made by him be allowed to be proceeded with. So this is the first filter. With and on hearing the applicant, the Settlement Commission shall within a period of 14 days from the date of application by an order in writing reject the application or allow the application to be proceeded with.
So this happened on 9th August.
Yes, my lord. My lord, this therefore means that this is a quasi-judicial process and there is application of mine in a prescribed manner with verification. And then if I don't pass the muster, then I'm out. Then I'm out. Then I face the consequences, whatever it is. Then, my lord, your lordships will, the scrutiny is at 2 levels. Then in the instant case, my lord, the Settlement Commission passed the order, as your lordships rightly said, on 9th of August and directed it to be proceeded under 245D1. Then, my lord, your lordships will have 245D2B. The Settlement Commission shall, in respect of an application which is allowed to be proceeded with under subsection 1, within 30 days from which the application was made, or in referred to in subsection 2A, which is deemed to have been allowed to be proceeded with under that subsection on or before the 7th day of so and so, call for a report from the principal commissioner or commissioner, and the principal commissioner shall furnish a report within a period of 30 days of the receipt of the communication from the Settlement Commission. Where a report from the principal commissioner or commissioner called for under 2B has been furnished within the specified period of 30 days, the Settlement Commission may, on the basis of the said report and within a period of 15 days of the receipt of the report by an order in writing, declare the application in question as invalid and shall send a copy of such order to the applicant and the principal commissioner or commissioner. Then 2D, where an application made under subsection 1 of 245C before so and so, and an order of the provision under such and such as they stood immediately before the amendment by the Finance Act allowing the application to have been proceeded with has been passed, but an order on the provision of so and so stood immediately such and such. I can skip this. Then 3, the settlement commission in respect of an application which has not been declared invalid. I was not declared invalid under subsection 2C may call for the records from the principal commission. After examining such records, if the settlement commission is of the opinion that any further inquiry or investigation is necessary, it may direct the principal commissioner to make or cause to be made such further inquiry or investigation and furnish a report on the matters covered by the application and any other matter relating to the case, and the principal commissioner or commissioner shall, but this is important, furnish the report within a period of 90 days from the receipt of the communication from the settlement commission. Provided where the principal commissioner or commissioner does not furnish the report, the settlement commissioner may proceed to pass an order under subsection 4 without such report. This was not furnished within the time period. He still relied upon this report. And there is no provision in the statute as to whether there can be condonation. Assuming that condonation is read in, but then I must be put to notice. That has also not been done. Then, after examination of the records and the report of the principal commissioner, the commissioner, if any, received under subsection 2B or 3, and after giving opportunity to the applicant, this opportunity is not given to me, and the principal commissioner to be heard either in person or through a representative authorized in this behalf, after examining such further evidence as may be placed, the report says that some further evidence has to come. I can point out those orders in due course, but that further evidence was not called for, but I was non-suited on this. With the provisions of this Act, pass such order as it thinks fit in the matters covered by the application and any other matter relating to the case not covered by the application, but referred to in the report of the principal commissioner. The settled commission shall pass an order under subsection 4 of this like follows. Then, my lords, on subsection 6 of this, every order passed under subsection 4 shall provide for the terms of settlement, including any demand by way of tax, the manner in which due under the settlement shall be paid, and all other matters to make the settlement effective, and should also provide the settlement shall be void if it is subsequently found by the settlement commission that it has been obtained by fraud or misrepresentation of so and so. I'll, my lord, at this moment, take your lordships, my lords, to one aspect that the settlement commission, by the order of 28th of September 2016, passed an order under 245D2 declaring that the application of the petitioner is not invalid. And while doing so, they observed that the points raised by the department would require detailed examination, verification for any final conclusive findings. Now, my learned friend, my lords, when his turn comes, will show to your lordships where is that application of mine. That is not there, as the record, my lords, with me shows. Therefore, my lords, 245C, in my most respectful and humble submission, my lords, pertains to a triple filter test. Triple filter, 245C. One is 245D1. 2 is 245D2B, and 3 is 245D2C. After having gone through this, there is no room either for the assessee or the assessor, the settlee or the settler, as the case may be, to interfere. It has to be based upon the Rule 9 report of the principal commissioner, because there's an earlier report also, which is that, my lords, 14-day and 30-day. Then there is a further report under 90 days, which is the Rule 9 report. So all of this, my lords, is well documented, well thought of, and sealed. So any person who says that during settlement, there's a demand of, there's an outstanding of 500. Okay, you pay 200 and get away. And this may take the form of a consent so that it can't be appealed. And nobody will look into it because it is consensus ad item. Now, this, my lords, is against the legislative intent.
No, but you did go before the commission to say you're ready to pay 125 crores.
Please not.
You did go before the commission and offered to pay 125 crores.
Yes,
is it?
my lord.
I see. How was that recorded?
That they say is all right, you have done that, but there is some more concealed income. And for that, you have agreed to pay 120 more. That has been paid. I went, my lords, with 145. 245C, this is what they say, forget that. I have perused, your application is not invalid. We'll call for the report. The first report came, the second report didn't come. It came belatedly. Now they say that you have to pay much more than what you. I am saying that this much more can be there, but then it can't be. Either it's a judicial scrutiny, a judicial order, one way or the other. You can't say that you have agreed. And because you have agreed for 145, so therefore now I will pass an order, making it a judicial order, that 145 is apportioned into 5 different heads, F2, F3, F9, and F31. And then we meet it as if the East and West have the twains never meet, Rudyard Kipling. Two bloods come to 145 crores and also a judicial order and a consent. So therefore you are done and sealed with. Over. This, I am saying, my lords, has been frowned upon by the Supreme Court in Ajmera. Your lordships may just see that judgment, my lords, which I have also extracted.
No, let's just, before we go to the judgment of the Supreme Court, let's see what the settlement commission has done.
Yes, my lord.
Let's see the order of the settlement commission.
Yes, my lord. Your lordships may, my lord, come to the writ petition. Lord, this your lordships will find from page 53 to 184. Order dated 31/7/2017. We noted, my lords, that this is phrase all in a day's work. This is all in 10 minutes. The hearing has lasted for 10 minutes. So your lordship sees, my lords, page 76 to 80 is issue 1, then issue 2, then issue 3. Now the absurdity of this is like this, my lord, that income in the hands of the sons, which have already been assessed in the income tax, paid for, have been reopened again. Similarly, my lords, mining, and which brings me to another aspect of the matter, my lords. And my friend can also, my lords, take a wholesome instruction on that. My lords, pursuant to your lordship's judgment in common cause, Justice Lokur's judgment, where those people who had mined without environmental clearance were asked to pay compensation. Lords, I have paid compensation to the extent of about 470 odd crores. Now, this is post the finding of the settlement commission, which is impugned here. Therefore, court asked me to file an additional affidavit. I have filed that additional affidavit to which no reply has come, setting out the payments made. Now, my lords, that if that be so, and there is a bar under the statute 245K, by which the settlement commission and the commissioner are functus officio, then if that be so, then, my lords, it has to be assessed as expenditure in my hands. Because one of the contentions before the Supreme Court, my lords, in common cause was that because there's a marginal note, this will be penalty and not compensation. Lord, their lordships held, no, this is compensation. If it is compensation, it is expenditure. If it is expenditure, my lords, it has to be so assessed. And this will then impact, my lords, at least the entirety of the matters there. Because I have paid all of this. Now, whether this really brings down, whether it goes to negative or wherever it goes, it has to be addressed. But it can't be, my lords, that I A, pay all the amounts. B, Supreme Court, my lord, says you pay this. I pay this. The settlement commission says I am factus officio. I will not look into it, and I am still, my lord, faced with that situation. So this is the typical 226. I can't be, my lords, without a remedy, and only a constitutional court, my lords, can come to the aid of a person who, and this fact is mentioned in my petition.
The order the settlement commission, I thought.
Yes, the settlement commission, my lords, deals with this. No, the mining part. I'll just go.
Page 648.
No. In the settlement commission impugned judgment, page 96. Yes, my lords. Illegal mining, page 96. Learned CIT states as under, as per Justice Shah Commission's report, so and so is engaged in illegal mining. The center has no environmental clearance for its Raikela mines, but continued its production. According to the report, excavation of iron ore are illegal. Moreover, as per the report, there was a difference of production data as per the records. The other mine, that is Sanandipur, was running under the provisions of so and so. They deal with this and they leave it. And at page 100, para 22, they say, in view of the submission of the applicant and also considering the joint verification, no adverse inference is drawn except the difference which could not be properly explained. The application has, however, offered and included the additional income of so and so. So this is also subsumed in the ceiling, threshold ceiling of 126 crores. No independent is given on this. And my lords, I'll just give your lordships the dates. The settlement commission, my lord, is dated 1st of August 2017. Huh? 31st July 2017. The Supreme Court judgment is 2nd of August 2017. And I paid the amounts, my lords, in 2018. Now, your lordships may just have the affidavit that has been filed, but I think that will clear the position. Lord, 2 affidavits have been filed. Your lordships can take the latest affidavit, which is in June 2021. Kindly have, my lords, that of June 2021, paragraph 3, page 2.
June 21.
I have made the averments in my petition at page 32 and 35 already.
Ah, 10th June 2021.
Yes, my lord. My lord, the necessary averments in my petition, in my writ petition before this honorable court, is at page 32 of the petition. Paragraph 20 onwards. Can I, my lords, I'm sorry for the inconvenience. Can your lordships, my lords, kindly be pleased to take the writ petition averments, and then your lordships may compare it with the additional affidavit. Page 32, my lords, paragraph. Just above paragraph.
Compensation directed to be paid.
No, my lords, compensation directed to be paid pursuant to the Honorable Supreme Court's judgment dated 2nd of August. After the pronouncement of the order of the Settlement Commission on 31/7/2017, the Honorable Supreme Court pronounced its judgment dated 2nd of August in common cause, in the said judgment, the Supreme Court has considered mining by various mining lessees in Orissa, including the petitioner here in excess of or without an environmental clearance, and has directed the state government to recover the price of the mineral so extracted under 21(5). It is pertinent to mention that the Supreme Court has treated the amounts to be so recovered as compensation consistent with the earlier judgments of the Supreme Court in Karnataka rare earth. But I'll take your lordship to that. The Supreme Court has further directed the state government to recover compensation at 100% of the price of the mineral from 2000 to 2001 onwards in terms of 21(5). In implementation of the judgment, the state government has already issued demand notices dated so and so with respect to Sanandipur and Railkela mines. The total compensation payable by the petitioner for Sanandipur mines under the demand notice is 209 and 192. Copies are herewith. Compensation payable for so and so for the relevant assessment years are such and such. These are the assessment years which have been dealt with by the settlement committee.
The settlement commission does not account for this payment at all.
Not at all. Because this was prior in time.
No.
Settlement commission was prior in time. Thus, the above amounts being in the nature of compensation are allowable as expense and have to be taken into account for the relevant assessment years. However, since the settlement proceedings were conducted post haste, prior to the judgment of the Supreme Court and prior to the petitioner receiving the above
Isn't there a
the said aspect would not
provision
have
where
been taken
you can go back to the settlement commission with a application for review?
Well, the problem is that there is a 245 bar by which they can't look into it. They become functus officio. So there has to be an order from your lordship, or my friend Mallards can take instructions.
Well, settlement commission is no more. It is in abolished on 1st February 21.
Because of this finance commission.
Yes, my lord. Yes, my lord.
What is it now merged with?
So that's the income tax settlement commission is so constitutional ceased to operate on or after the first day of February 21.
So what happens to what happened to all the pending matters before the settlement commission?
Constitutional interim board of settlement has been made and 245 AA.
245 AA.
Only for pending cases, your lordship.
No, I know. But what happens to challenge to orders of settlement commission pending in the high courts?
245I, it has already been settled that all the order of settlement are conclusive and binding, and this honorable court have already passed this order.
245I, my lord. Order of settlement to be conclusive. Every order of settlement.
That language that it is conclusive applies to not the high court, please. 245I.
Every order of settlement passed under subsection 4 of section 25D shall be conclusive as to the matter stated therein, and no matter covered by such order shall save as otherwise provided in this chapter be reopened in any proceeding under this act or under any other law for the time being.
That's right. That is as far as the Income Tax Act is concerned.
Yes, ma'am.
But what about challenges to the settlement commission orders which were pending in the various high courts?
Interim board.
Where is that?
243 has been constituted on 1/2/21.
Where is that? Where are you reading?
245A.
New act.
No, we have the new act only. 245 AA.
AA. The central government shall constitute one or more interim board for settlement as may be necessary for the settlement of pending application. Every interim board shall consist of 3 members, each being an officer of the rank of chief commissioner, as may be nominated by the board.
No. Have they notified these interim boards?
Yes, no,
they have not.
That I have to inquire, my lord.
Because
it is the 1st February 21 that notification is issued.
That was also challenged, wasn't it, Mr. Sharma? The abolition of the settlement commission has not been challenged.
Lord, must have been challenged, Lord, but I'm not aware of the true position. Can't commit myself either which ways. My friend may take instructions on this.
Yes, I will take. What is the latest position?
Because in any case, my lord, such a huge demand, it has to be factored in this way or that way, whichever way it has to go.
All right.
But it can't be left indeterminate.
All right. We say the challenge in the present petition is interior to an order dated 31st July 2017 of the Settlement Commission bracket.
Well, apart from that, I have some small written submission, 3 pages. Let me kindly see.
You'll have to give him a copy, but more importantly, you have to collect all the.
But this written
affidavits that
submission
he has
is behoves
filed.
my rejoinder. Or did you take into account what my rejoinder would have said?
That I've said, it's a small reason.
Or can you just say it's not mandatory, sir? Para 5. You say the time limit for submission of Rule 9 report is procedural. Time limit is not merely procedural. No? It serves a purpose. So you concede it is based on the Rule 9 report.
The pipe.
So if you concede, because in internal page 4, you say the commission has not based its finding on the basis of the Rule 9 report alone, which means it has taken into account that Rule 9 report. So that Rule 9 report is submitted without giving them a copy. You're virtually conceding the case. I think what is valid in your note is not valid, meaning to be considered is what happens when the settlement commission stands abolished. Then do we send it back to the interim board? If it is called interim board, then does it have the same functions as the settlement commission?
No, that I've been inquired from the commissioner.
So if this is interim board is only to consider all the leftover matters of the settlement commission,
yes, sir.
What happens to the concluded matters which are going to be set aside and sent back?
That I'll give the report within 7 days.
So one possibility is this. Suppose the settlement commission's order goes, it's as if there is no settlement. Then it goes back to the regular assessment proceedings.
Yes, Lord.
That can be the only outcome.
That can be the one. If they say that the
there
new
is no,
board,
because the word interim,
that's right,
seems to suggest that they do not want to continue with the concept of settlement commission. This is only to conclude all the pending matters of the settlement commission. The concept of a settlement commission they want to do away with. That seems to be the
that does seem to so. And it has to be, it has to go and it has to be de novo.
All right.
But my friend can take a
inter alia
interim view of the matter.
Yeah, inter alia, the grounds of challenge to the impugned order of the settlement commission is that the report that was mandated under Rule 9 of the income tax rules. This is income tax rules, is it? Or there's the settlement commission rules?
Settlement commission rules.
You have the text of the Rule 9?
Rule 9. Writ petition.
Income tax rules. The whole separate book for income tax rules.
Income tax settlement commission procedure rules 97.
Where is that? My lord wants that, no?
Income tax settlement commission bracket procedure rules 1997 was submitted stage on 10th February 2017. And that the petitioner was not afforded an adequate opportunity of hearing in relation to the 31 issues raised in the said report. Another ground raised in the writ petition in para 20 of the writ petition is that after pronouncement of the order of the Settlement Commission, the Supreme Court of India pronounced its judgment on 2nd August 2017 in writ petition civil 114 of 2014 bracket Common Cause versus Union of India. As a result of which, the petitioner paid a total compensation amount in the sum of rupees 209,44,21,667 for the Sanindupur mines and rupees 192,67,53 060.36 for the Raikela mines. According to the petitioner, this is
those are the amounts without interest
in the hands of the petitioner, which should be allowable as such for the relevant assessment years. That is 2008-09, 9-10, and 10-11. We're talking of 3 AYs, right?
Not those amounts that your lordships have mentioned are without interest, because then interest accrued for 1 year. Those interests have also been
bracket
paid.
Without interest. All right.
My lord, meaning of pending applications is given there. Yes. It
Where
is
is
EB. EB 245 DAB. Meaning of pending application. Means an application which are filed under section 252C and which fulfills the following condition, namely, it was not declared invalid under subsection 2C of section 245D and no order under subsection 4 of section 25D on or before the 31st day of January 21.
So correct. So this is not a pending application.
Yes.
So this will not therefore go before the board.
Yes.
But what if the High Court sets aside this order of the settlement? What happens then? Can it be sent back? Suppose we agree with him that this issue about the payments made by him pursuant to the common cause judgment should be treated as allowable in his hands, and the department says no, it is not allowable. That issue, who will decide? Paragraph. Another development that has
I'll
taken
contact
place.
The commissioner will.
During the pendency of the present petition before this court is that by virtue of the Finance Act 2021 with retrospective effect from 1st February 2021, the Income Tax Settlement Commission stands abolished. And instead, Section 245 AA, titled Boards for Settlement, unquote, has been inserted. Full stop. Under 245 AA 1, the central government shall constitute one or more interim boards for settlement as may be necessary, open quotation, for the settlement of pending applications, unquote. Paragraph, the expression single quotes pending application, unquote, has been defined under section 245 capital A bracket EB to mean an application in respect of which no order under section 245D bracket 4 was issued on or before 31st January 2021 in respect of such application. Full stop. Paragraph clearly in the present case, since the settlement commission has already disposed of the petitioner before it, finally on 31st July 2017, it cannot be considered to be a single quote pending application, unquote. Paragraph. The question that then arises is, if the petitioner, if this court were to agree with the petitioner that the settlement commission ought to have considered the effect of the payments made by the petitioner pursuant to the judgment of the Supreme Court in Common Cause versus Union of India Supra, and in light of the stand taken by the revenue in its single quotes additional written submission handed over in court today that such payments are not allowable as expenses in the hands of the SSC for the relevant AYs. Can the matters be remanded to the aforementioned interim board of settlement? And if not, what is the remedy available to the petitioner? Question mark. Mr. Chimanka, learned counsel appearing for the revenue, states that he will have to seek specific instructions on the above and prays for an adjournment. Paragraph. Copies of any of the pleadings filed by the petitioner, in addition to the main petition and the rejoinder, be served upon Mr. Chimanka within the next week. It will be open to the petitioner to file its written note of submissions in response to the written note submitted by Mr. Chimanka today before the next date. All right.
Not
interim orders to continue.
Not if it meets with your 10th or 17th December as it meets with.
No, not December. We'll have to go to the next.
I said subject if it meets with the approval of the.
No, it's just too heavy here. So we'll have it on subject to what you might say. Would you prefer a Monday or a non-Monday?
Either a Monday or a Friday.
Friday. All right. 14th February. Or 14th February. Or would it 21st be better? 21st. Okay. 21st February.
Very good.
All right.
Deeply obliged.
All right. Let us sit with them and explain. Yeah.
Item number 20.
Yes. Who's for the other side in your matter? You're there. All right. Advertisement. Yes.
My lordship, kindly see page 14 annex 1 advertisement.
Yes.
That is serial number 1, junior clerk cum copyist.
Yes.
For your 2, the petitioner belongs to your category. Your 2 total post is minor, total post 7. Petitioner, after written computer test and viva, was selected. Your lordship, kindly see annexure 5, page 34.
Yes.
Page 34. My name is serial number 2, Prashant Kumar Das. You are.
Yes.
2 post, 2 persons recommended, man.
Right.
the information received from the RT Act under Annex 6 reveals that they have given appointment to others category so far as SC, ST, OBC are concerned, but so far as UR is post is concerned, no appointment was given. Lordship kindly see page 35. They have given the date of appointment 37/2019 so far as other post is concerned, other category is concerned, my lord. And so far as
question number 2, they say none.
Question number 2, none. And question number 3 is important. Number of vacant posts of junior clerk copies shown for unusual category in advertise number 1 of 2018. My advertisement also 1 of 2018. And number of present existing vacant posts. Advertisement 2, vacancy nil. And no. Question number 2, none was appointed. So far, unusual category is concerned, my lord. Your lordship kindly see another advertisement. This is 2018 advertisement, and 2019 advertisement was made at page 47, Annex 10, my lord.
So nothing shown for unreserved.
Nothing, my lord.
So they've utilized the 2 unreserved vacancy for some other category.
So SC category.
SC category.
SC category. My averments in para 8 and 9, the learning districts has not replied, my lord, while filing counter. I have specifically mentioned. And they have mentioned in the counter that 80-point model roster has been maintained. 80-point model roster has been maintained while filling up the post. Your lordship kindly see, I have also enclosed the 8-point model rosters, page 41, my lord. Kindly see page 41. Even if, my lord, in the first 2018 advertisement, total 7 posts, and thereafter in 2019 advertisement, 6 posts, 13 posts. If the 80-point model roster is maintained, my lord, then they should keep for your posts, at least your post, my lord. In the information supplied, my lord, your lordship kindly see in my rejoinder I have mentioned. Rejoinder. Information supplied by the learned district judge at page 59, Annex 11. May I read, my lord?
Yes, please.
Serial number 1. 8-point roster has been prepared separately for the promotional post of base level post in the cadre of junior clerk copyist of the judgeship. Further, roster register has been maintained for the recruitment years 2017, 2018, and 2019 for the post of junior clerk copyist, and roster register for promotional post has been maintained after promotional post by your promotion in different years. The copies of relevant pages containing roster points of the roster register, both promotional base level post, could not be supplied as the same violates Rule 5, Chapter 6, Chapter 4, miscellaneous of the High Court, Orissa, Right to Information Rules 2005. Lordship kindly see paragraph 2. Number of vacancies in the cadre of junior clerk copyist in the years 2016, 7 posts. 2017, 8 posts. 2018, I am concerned with 2018, 7 posts. Your lordship kindly see para 3, number of newly created vacancies in the cadre of a junior clerk copyist created by the government of Orissa for Kendra Pradesh with 2 numbers. Number of your vacancies filled up through recruitment examination conducted in the year 2016, no recruitment. 2017, 4 numbers they filled up. 2018, nil. 2019, nil. Your lordship kindly see, so far as 2016, 17, 18, 19 figure they have given, in my rejoinder I have mentioned at page 57.
Yes.
Fact, my lord.
Yes.
2016, total 7 post vacancies, my lord. Total number of EUR required 3.5, even if rounded to 3, my lord. Not a single post filled up. So far as 2017 is concerned, my lord, out of 8 vacancies, 4 filled up to EUR. So far as 2018 is concerned, not a single post filled up. Total, my lord, from 2016 to 2018, 22 vacancies, my lord. 20 out of 22 vacancies, only, my lord, 4 were appointed. And their counter, the lordship kindly see their counter. Paragraph 7, the explanation, paragraph 7. Page 52, running page, my lord, 52. May I read, my lord?
Yes.
In reply to the affirmations made in para 10, 12, 14 of the repetition, it is humbly submitted that this judgeship was bifurcated from the judgeship of Cuttack and started its functioning since 26/6/2012. And at the time of bifurcation, some staff different grades and cadres were deployed to this judgeship, and some posts of different grades in different cadres were lying. And after the bifurcation of the judgeship, 8-point model roster register was maintained for the candidates who were initially appointed in this judgeship, irrespective of the categories of the candidates deployed in this judgeship at the time of bifurcation from the parent judgeship up to the year 2018. As for vacancy position submitted by the recruitment cell, after completion of a recruitment process, office to the post of grade 3 bench clerk. After taking into consideration of their seniority in the gradation list, CCRs and performance report
Item 20.
May I please, Your Lordship?
Yes.
I have read paragraph 7, Your Lordship. Kindly see paragraph 8 of the counter at page 53, my lord.
Yes.
Running page 53. That it is humbly submitted that the petitioner was selected to be appointed for the post of junior clerk cum copyist, yet he could not be appointed due to lack of vacancy in the best available post, that is junior clerk cum copyist, for the candidate coming under your category. Apart from that, even if the name of the petitioner appears in the select list, yet he does not acquire any indicible right of appointment in the post of a junior clerk cum copyist of the judgeship, as there is no vacancy in the best level post for the candidate coming under your category. And the advertisement was published showing vacancy of 2 posts for the candidate coming under your category inadvertently. In the meantime, advertisement for the recruitment year 2008 has already been published to fill up the vacancies arose in the best level post of a junior clerk cum copyist, and the merit list prepared during recruitment year 2018 become invalid, inoperative. 2 things they have said: inadvertently, and merit list become invalid and inoperative. Thus, the appointment of the petitioner to the post of junior clerk copyist has not been ignored deliberately with malafide intention, and there is no arbitrary malafide or discriminatory action on the part of opinion number 3. The above act of opinion number 3 in not giving appointment to the petitioner is not violative of Article 14(16) of the Constitution of India.
No, but what's the factual position? Were the vacancies? See, one is they saying there were no vacancy. By mistake, we showed 2 vacancies in UR when in fact there was no vacancy.
My lord, out of total in 2018, 7 posts are advertised. Out of 7 posts, there should not be reservation exceed beyond 50%, my lord. Unreserved entitled 50%. Even if they earmarked only two, my lord. In the next recruitment year 2019, they included my specific government in para 1890. They included, they have not given answer and converted to AC. And the counter, they did not mention about what is the roster, what point they, whole point number 10 or 20, they will start, they will count, my lord. You will lordship kindly see the roster, maintenance of roster. I have annexed, my lord, how to maintain roster as per the guideline of the government. That is page 38, my lord. Page 38. Second para, may I read, my lord?
Yes.
Rule 4.5 of the ORB rules provides that the roster will be maintained in form of a running account year by year. Since the roster is to maintain in form of a running account, the appointing authority is required to determine the status of the vacancy as per next roster point in the reserved 8-point model roster with effect from 21/4/94. For example, if the appointment has stopped at point number 10 of the 100-point model roster on 24/94, the next appointment will be made against point number 11 of the revised 8-point model roster effective from 21/4/94. Where, however, the roster point has already crossed the point number 80 prior to the amendment rule came into force. Subsequent roster start from point number 1 of the 8-point model roster effective from 21/4/94. With due respect, my lord, the counter is vague as anything, and also they have not supplied information on the Act saying that this will not permissible under Right to Information Act, my lord. Supposing for the sake of argument, my lord, roster has been maintained as per their counter. Total 8 posts required to fill up in 2017. Out of 8, 2017, they have given 4 persons to meet for your category.
No, Mr. Lenka, I think how we should approach this is this. Ask how many sanctioned posts of junior typists are there?
30 posts, my lord. I mentioned in the regender, I have given the chart, my lord. 30 in the regender. The lordship kindly see. Page 50, running page, my lord, 57.
Yes.
I've given the year-wise chart.
No. What is the sanction strength you have not given? You try and understand.
My lord.
Let's say sanction strength is 30 or 20, whatever. Number of people already in position are 18.
My lord.
Vacancy will be only 2.
My lord.
So you cannot advertise for more than 2.
My lord.
So what is the factual position on that? UR category, in UR category, what is the factual position?
I have requested to supply the RTI, they did not supply, my lord.
No, I don't know whether you asked for sanction strength. See, unless we know what is the sanction strength, working strength, we can't know vacancies. Because that stand seems to be this. Vacancies available in the baseline, base level. Maybe vacancies are available at the promotional level, but not at the base level.
Base level.
So if there are no vacancies in the base level, how can we take on persons in that UR category? That is the stand. But have you actually categorically told us what is the sanction strength and what is the working strength?
That is not there.
You should. You can't simply make a claim. You're not even supplying him RTI. And then you'll have to show us how you're working out the 80-point roster. Yes. We'll ask them to file an affidavit. You say a direction is issued to the respondents to file an additional affidavit answering the following questions. 1, what is the sanction strength in the base level post of junior clerk cum copyist? 2, what is the working strength?
Your Lordship may kindly mention that after creation of the Kendrapada judgeship.
Yeah. After creation of Kendrapada judgeship and category wise, that is UR, SC, ST, and so on. 2, what is the working strength year wise from 2016 onwards up to 2019 in each of the above categories? 3, consequently, what is the vacancy position vis-a-vis each of the categories, namely UR, ST, etc. 4, how was the 80-point roster actually worked vis-a-vis the filling up of the vacancies? 4, were there any vacancies meant for one category utilized for filling up of other vacancies? Namely, was a UR vacancy used for SC and vice versa? Question mark. The affidavit be filed at least 1 week prior to the next date with an advance copy to the counsel for the petitioner. List on 18th January.
Item 21.
May I please, Your Lordship? I think Mr. Tripathi is leading in the first matter. I am in the second matter, my lord.
All right.
May I submit, my lord? Today I have filed objection to the agent. Mr. Ponda is there. I may be excused, my lord. You will hand over the objection to the agent. Already hand over to the court, my lord. Second matter, Mr. Ponda is with me. The copy also
research
to Mr.
Yes, my lord. Yeah. I'm sorry. This is a very vital and very important matter for the region, my lord.
I think Mr. Mahapatra is appealing for the employees is concerned.
Yes. I am in the second matter. I have already mentioned that.
In the second matter, we didn't have filed, but first matter, what Mr. Tripathi is filing, in that matter of filing objection to the region, it may be taken to record. In that case, we have last occasion, my lord, put a very pertinent question to the central government. That whether it is a policy decision or unanimously a decision has been taken to shifting the ICMR unit from Raulkela to Ranchi.
Right.
It is a policy decision of the government of India. It is not only that we have taken decision as regards to Orissa is concerned. There's 2 units in merger. One is at Raulkela in Orissa, another is at Bhopal. And what principle we have adopted and success in the Orissa, the same principle will going to be adopted in Ranchi. That's why this is the decision when the researching unit, those have taken the decision that if the same principle what adopted in Orissa, the same thing will be implemented in Ranchi, then this research work can be control the issue as regard the malaria part is concerned. Other thing we have taken, we have our office research unit function in Bhubaneswar. There is ICMR unit is there. It is not that entire thing is abolished.
No, no, but what about the relief for people suffering from malaria and where will they get special?
But that is in my lord. They have the state government has already opened 9 units in Raulkela. Apart from this, the health mission is not a party, but health mission also taking care of all this. Whatever help they are required to extend from our side, we are extending. In that detail, also we are also asked all these things from them. They are giving all details to my lord. I will file the court if lordship will adjourn some other day. But relevant thing is that, my lord, what as regard to the lordship may see the paragraph. Because the last occasion also lordship is the state government is in our party, health mission is in our party. That's why they will come forward a band that what steps they have taken as regard to the treatment part is concerned, how their health mission is functioning for all these control, all these things. We are the research unit. Apart from this, we are extending the help. But the health mission is the only organization who will take care of all these things, apart from us.
I'm sorry, my lord, on behalf of Mr. Party, my lord. I was told that this objection was filed just before launch, my lord.
Correct.
So, lordship may kindly allow at least 1 week time to
For it,
go through
Mr.
this.
Pari has handed over an objection to the rejoinder affidavit filed by the petitioner in WP Civil P. Now 2021. Mr. Pari points out that the state government has to be made a party, and its response sought in regard to the availability of health facilities in the area. Under the National Rural Health Mission,
You also recorded.
is it the, Mr. Pari, you are talking of the National Rural Health Mission?
Yes.
NRHM.
NHM.
At his request, the government of Orissa through the Secretary Health and Family Welfare.
But that is a Union of India, that national.
But the
government of India is already a party.
Yes, government is a party, health ministry is a party. Yes, but there is a two-step. NRHM is functioning through the state health mission.
That's what.
So health mission, NRHM, both should be party. Otherwise.
Exactly.
Right. Yes. The National Rural Health Mission through the Union of India Ministry of Health is also implemented as opposite parties. The amended cost title be filed within a week. Notice will issue to the newly ordered opposite parties 6 and 7 as above. Returnable by the next date by registered speed post. Mr. Mudli or one of you can accept for state?
Yes.
You say notice, Mr. Mudli accepts notice, and for National Rural Health Mission, you accept notice, Mr. Pari?
Yes.
All right, then you say both of them accept.
Both the cases,
both newly added respondents will file their respective affidavits within 4 weeks.
In the second Millard, in this writ petition 4027.
Yes.
The second Millard.
Yes.
There, Millard, I am appearing on behalf of the Malaria Research Center Project Employees Association. And the reason why I am before your Lordship is I'll invite your Lordship straightway to page 26, Millard.
Yes.
Millard, look at the state, Millard, so and so means there are 19 employees, Millard. If your Lordship has got page 26, Millard, there are 19 employees. Correct. And if your Lordship, straightway I'll take you to your Lordship, Sri P. Pradhan, the first name itself, Millard. Date of retirement is 30th, although he is already retired, 30th/6/2021, Millard. Before that, I had filed this writ. And by this way, Millard, if your Lordship can see 22, 23, 20, all these people. Millard, after putting 32 years in the same department without giving a transfer order, they were straightway given the relieving order. This is
relieving to join.
Yes.
Sir, relieving.
No, I'll show your Lordship now. But kindly appreciate before that, Millard. I'll just take 1 minute why even the policy will be bad in my Millard. If your Lordship will come to annexure 2, Millard, that is at page 22. Although that is a subject matter of Mr. Tripathi, but I'm just encroaching on that issue because I am also my lord appearing for the association, and I must bring to your lordship's knowledge. Look at this, my lord, issue. This NSR P2, your lordship has got, my lord. This is the strategy of all the states. How many patients, how many malaria patients are there in state-wise? Now, they have taken a decision without any justification. My first argument will be, even if you have taken a decision after putting 32 years, at least you should have asked our consent before relieving us or before transferring us. Now, let's look at Orissa. The number of malaria patients are the highest in the country. Now, if you are talking about Goa, where you are sending me to Ranchi, the number of malaria patients are very minimal. Now, more interestingly, what we are doing is my health now, what the learned AG has argued, state is looking after, but we are under central government, and our duty was not only to give protection to this malaria patient, but to do a lot of research. My research will go west, my lord. Just one more thing, my lord.
No, you'll go and work in Ranchi. You've been sent to Ranchi.
No, my lord. Problem is that they can always send. I have no difficulty, but for a transferable, my lord, the law has been laid down that at least before 3 years of retirement, I should not have been transferred. That is one. Second, my lord, even if you do it, you have to take my consent. Suppose if you don't.
It's a policy decision. It is across the board.
But problem is that first petition is.
See, the affidavits filed in the first
in larger
petition.
interest of the state, the employees should not huddle. My lord is taking care of about the larger interest of the state. If the malaria immunity
if it is a larger interest of the state, I will keep quiet.
Coming with
but
such
when it is not in the interest of the state, I will definitely object.
As they have filed application, it was be listed with honorable single judge, then it was dismissed, then again another group has filed another petition. Coming in the
Lord, I am challenging. With all due respect, my learned friends should know that yes, I am challenging the transfer order. Not only that, in their own districts, Lord, I will show you, Lordship. They themselves have said, "Now this institute will never be transferred, or no decision has been taken to merge."
Mr. Mahapatra, no, 1 minute, Mr. Mahapatra. All your clients have now joined there in Ranchi or not?
Lord, not only Ranchi. I will tell you, Lordship, they have not only specifically transferred to Ranchi. Some of them has been transferred to Goa. I will show you, Lordship.
No, have they all joined or not?
We are bound to, because after all, Milord, the harsh decision we cannot. I'm sorry, Milord.
No. Can you confirm to us that all of them have joined?
Milord, we are bound because the office is not in existence. But I will just tell you, Lordship. I will find out.
All right. By the next date, in the second matter.
But my instruction is that yes, they all have relieved and they have joined me, Lord. This is my instruction. Anandita is with me.
Some are drivers, some are chowkidar. Whatever their concern to the research part. They have those persons are there.
The court will be informed on the next date, both by counsel of the petitioner as well as the learned assistants also general.
Milord, then this is more important. If driver and helper.
Whether all the employees at the Rourkela unit have in fact joined at the places of transfer.
Yes.
List on.
Keep some
13 January.
In this case, Mr. Satyavrata Panda is appearing with me, Lordship.
All right.
In court.
Grateful.
Another case, Mr. Gupta is appearing. First case.
Okay.
Not only one request. Can it be on the top of the times, Milord? This matter reached at 3:45, and
my
in
lord,
that way, Milord, your Lordship.
No.
Today, fortunately. Today, fortunate. I am fortunate. I am fortunate.
No, don't worry about that at all. It will go on in this court, it will go on.
Not can.
All right.
Item 22.
Right.
Milord, it will be always a privilege to come before your Lordship. How many times I'll come, I'll take that privilege.
All right.
Grateful, your Lordship.
All right.
Item 22,
may I please your Lordship?
Yes.
This is regarding this 2% reservation for the transgenders, my lord. In this case, we have received PwC from both the department, my lord. We've actually granted a short debt, very short debt, my also we do, my lord, to file the.
All right. Counsel for the state seeks and is granted.
My lord, can I make another submission, my lord? My lord, earlier also a writ petition was filed, my lord, in the similar ground, my lord, for 5% reservation. That was disposed of by this honorable court on 5/2/2019. Should that be tagged along with this, my lord?
Yeah. Give us the number.
Yes, WPC number 2276 of 2019.
Yeah, the file of that writ petition be requisition for the next date. Counter be filed within 4 weeks, rejoined up for the next date. List on 23rd February.
Item 23. Item number 23.
Item 23, pursuant to order dated 3/11/2021, I have filed a counter affidavit of the opposite partner 1 to 3. That is not in record.
Yes.
I filed the hard copies today.
You say counter affidavit on behalf of 1, 2, and 3 has been handed over today in court by Mr. Mudali. Who's for the petitioner?
I am for the petitioners.
So rejoinder if any be filed for the next date.
Lordship. Lordship, I have also filed a rejoinder to the compliance affidavit. That may be taken on record. Lordship. Let us file.
Copy to be
Just on 24th February.
Item 24.
Acha, who's right? All right. Item 24.
Item 24.
Also. 24 also. My Lord Senior has filed a written note of submission. To that, I am filing the reply. But the steps taken on his concern, on her concern, ma'am. I could not sort a copy on her.
Miss Paddy?
Yes, my lord.
He has submitted today a reply
Yes, my lord.
to your written submission. I think you should take a look because now he's given more details district wise.
Okay, my lord.
All
My
right.
lord,
Yes, my lord. Last occasion, my land senior also asked me to file the counter. We have prepared the counter. It is on the process of waiting, my lord. If lordship give 3 weeks time, in the meanwhile, file the counter. We have ready with everything.
Mr. Pari's learned ASGI states that counter affidavit of the Union of India will positively be filed within 3 weeks. The state government opposite parties 2 and 3 filed a reply to the written note of submissions filed by the petitioner, which is taken on record. A copy thereof we serve on the petitioner forthwith. Rejoined if any to the affidavit of Union of India be filed for the next date. List on 16th February.
Oblige.
All right.
Item 25.
Mr. Kashyap name is reflected along with me.
All right.
Item 20.
Lord, in item 25,
Yes.
Lord, I am for petitioner, my lord. Item 25.
Yes.
The state is to file counter affidavit, my lord.
Recently, I have received the Parawaj comments. I pray some time to file the reply.
All right. Mr. Mudali
Lord,
states
may I
that
point
he
out
filed-
one more thing, my lord?
Right.
May I point out one more thing, my lord?
Yes, 4 weeks.
In Lord, in order dated 7/5/2021, my lord directed that this matter should be tagged with fomento matter, my lord. But in para 3, the read petition is not written correctly, my lord. That's why it is. So correct petition number is, my lord, 6152 of 2021. But it has been written by mistake, my lord, by typo mistake, 64152. That's why registry is not tagging both the matter.
All right. 6512, is it?
Yeah, 6152 of 2021.
All right. You say the in para 3 of the order dated 7/5/2021, the writ petition number be corrected as 6152
6152 of 2021.
of 2021. Then you say, Mr. Mudali prays for and is granted 4 weeks time to file reply. Rejoinder for the next date, interim order to continue. Just on 7th March.
Deeply.
26.
Item number 26, Your Lordship, the petitioner challenged the virus of section 16. Your Lordship, I may be permitted to file the counter 4 weeks time may be further granted.
All right. Mr. seeks and is granted 4 weeks to file a reply. What about Union of India? Is it necessary to file a reply?
Yes.
I didn't have any discussion.
All right. You say the interim order to continue, rejoinder if any before the next date. That's on 14th March.
Published.
Item
14th March.
My lords, on which date? On which date, my lords, it's coming? 14th March. 14th March. Interim order to continue.
Yes, yes.
Item 27.
May I please your lordship? Item 27 counter has not been served yet.
Counter has been served.
We haven't received yet.
My lord, I
think it will come on record, Mr.
We haven't received yet.
On this counter affidavit has been filed today by the.
My lord, we have filed the counter affidavit and we have also served the counter affidavit.
No, we haven't received yet, your lordship.
Copy thereof be served and counsel the petitioner today itself. Rejoined for the next date.
My lord, may I submit one thing? This is relating to that SCB medical project area. And your lordship has directed status quo. We have submitted in our counter. Just for a minute, I am submitting.
Show the counter.
That lordship may guide. We are not going to forcibly acquire his land. We have got two options. Either he will sell it by direct purchase or we will go for acquisition. At this stage, we have not taken any decision. So this allegation is very much premature. There is no.
I think we'll record a statement then.
Yeah, your lordship, let us receive the counter, then we will file a rejoinder immediately.
Yes, my lord, lordship, next week, your lordship. Today I will.
Yes, your lordship, interim order may be continued.
That's the whole thing. He's saying there's no need for that because they're not even going to take your land.
Your lordship may be continued. Next date we'll.
There is no question of taking anybody's land without following due recourse to law.
Why don't you just record that statement and close the matter? That's more than enough for you.
Your lordship, next date the senior is not well.
Para 11 may kindly be seen of mine.
We'll just reproduce that para 11. You say counter affidavit has been filed on behalf of OP number 2 and 3, para 11 of which states is under paragraph. Mr. Mohanty, AGA reiterates that the apprehension of the petitioner about the land being taken away forcibly is entirely misplaced and in fact is premature. He states that as of now, no decision as such has been taken.
Para 11 and 12 may kindly be taken.
Whether to acquire, if at all, the land in question. And if it is so, then the petitioner will be approached for direct purchase.
That is what
there's no question of not following the process of law.
That is what I have submitted, that the petitioner may come forward for any direct purchase because we are paying lump sum amount. Because once the land action process
matter, no further directions are called for the petition's disposal. All right.
Item 28.
May I please, your lordship? In this case, my lord, the petitioners, my lord, being the street vendors, and this case for their rehabilitation, my lord. But they have, my lord, they had already, my lord, submitted the license fees to the municipality, my lord. And my lord, if with the lordship permission, I want to drag attention.
You served it on BMC.
Yes, in the last occasion.
Who's appearing for them?
My lord, senior Mr. Vibhudendra Das. I already served the copy, my lord.
Where is he? Mr. Das?
Item 29.
Item 29, counter or not filed?
I pray for some more time.
Mr. Modi prays for and granted 8 weeks time to file reply. He joined within 4 weeks thereafter, list after 12 weeks.
Interim order to continue.
Interim order to continue.
Date may be please.
All right.
For hearing item number 30.
My lord, in this 31, effects have not been removed yet. My lord, what happened? My learned sister, in fact, mentioned with regard to the substitution. The respondent number 1 died, my lord. Right. Last occasion mentioned. I also, he gave me the information regarding certificate also legal hairs. Immediately without delay, my lord, even if that holidays, my lord, today also I filed that substitution petition.
Then
that is mentioned in 2221 of 2021. That has not come before this lordship.
It's not shown in the
is the impugned order. They retired on 29/2/2016. That is the retirement order that is challenged. But you can see the prayer at the moment. The prayer is, my lord, very specific. In the prayer, my lord, that is prayer person is in the my lord 21. But if kindly see 21, the prayer. Page 21, my lord. Let's have got that.
Prayer in the writ petition, right?
My lord, in the writ petition.
Yes, yes.
I'm in the writ petition.
Correct, correct.
In the 21, in the prayer, it is therefore the issue the so-called insufficient cause issue appropriate direction and other commanding opposite party number 2. 2 means my state. The original department, nodal department is my science and technology department. In these 6 to 6 months back, my that now is in the energy department. So commanding the opposite department 2 and 3 is the present applicant, Orissa Renewable Energy. To implement, that is very relevant, to implement the policy decision of the state of Orissa taken under Annexure 1. Let us come to the Annexure 1. So they wanted to implement Annexure 1. What is Annexure 1? What is the Public Enterprise Department's notification? Annexure 1 is, my lord. Annexure 1. Let's kindly see page. I'm sorry, my lord. Annexure 1 is page 23. I'm sorry, my lord, because I'm so late. Annexure 1 is page 23.
Yes.
So because this is the crux, my lord. But the entire case stands on this notification, my lord. Let's kindly say Annexure 123. What is the Government of Orissa Department of Public Enterprise Department? So may I permit you to read, my lord? That notification not required.
There's no need for the whole thing. Basically enhances from 58 to 60.
But 58 to 60, that is the government notification issued. But if the P department is subsequent another date after 6 to 7 months. Earlier is the government notification. Let's say date chart. Date chart. Let's say kindly see in my date chart. In my date chart, sorry.
What we have is a 2nd August 2014.
My lord. Oh, yes, my lord. Yes. Like 28/6/2014 is the government. In my date chart I've written.
Yes, yes.
In the date chart also, I annex that. Let's kindly see the annex 28. I'm sorry, my page 10. Page 10 of my date chart. I'm sorry, my lord, because I'm putting you in trouble, my lord. Around 9, 8. Page 10. Page 10 is the Government of Orissa government notification, Finance Department notification, 28/6/2014. Let's see, got that. In my date chart, that is page 10. All these things also referred in original rate application. Also, the judgment also referred all these things. Let's see, got that 20 June 2014. Let's see, file.
Yes.
I'm reading. The enhancement of retirement age of superannuation of state government employees as per Rule 71A of the Odisha State Service Code, the government servant except Group B employees shall retire on the afternoon of the last day of the month of which he completed the age of 50 years. There is significant improvement in such and such, that is not relevant. Government, after careful consideration, have decided to enhance the retirement age of the state government employees on superannuation from 58 to 60 years. This will take immediate effect. The relevant provision under Rule 71 of the Odisha Service Code, as well as provision in relevant rule of the OCS pension rules, such and such, shall be deemed to have been modified to the above extent. Necessary amendment to the above rules shall be issued in due course. So what happened, my lord? The state government amended the rule 71A and enhanced the age 58 to 60. That is, Lordship kindly come to then Annexure 1 of the read application, page 23. Then subsequently, what happened? Department of Public Enterprise Department, this all corporations and PUCs coming under this Public Enterprise Department, they issued this notification dated 2/8/2014. In the 2/8/2014, my lord, what he said, what is the exact language of that notification, that is very relevant, my lord, because that is the entire case of mine, my lord. Lordship, see, consequent of an enhancement of the age of superannuation of state government employees from 58 years to 60 years, similar enhancement of age of retirement of superannuation of the employees of the state public sector was under active consideration for the government of Orissa, keeping in view the demand of the various service association of the state public sector undertakings, as well as significant improvement in average life expectancy in recent years, state government have been pleased to allow enhancement of age of retirement on superannuation of the employees of the state public sector undertakings from 58 years to 60 years, subject to fulfillment of following conditions. So this is my case. What are the conditions? The respective public conditions by the respective public sector undertakings. So this is my client is the society, my lord. He doesn't belong to any public sector undertakings. That I annexed. That was my case also. So let's see.
So what did the single judge hold? Let's see that.
My prevention. No, Lassif said that this Orissa renewable energy is not a public sector undertaking. He said that is a public sector undertaking. I said that is not PSU.
Sir, with your permission, can we read the judgment of the single judge?
I'll read. My permits are 1 to 3 minutes, but I will read this notification. Then I'll come.
I'm sure this is discussed in the single judge's order.
But all things are discussed. I'm obliged to honor single judge, my lord. He dealt everything. He dealt everything. He also learned honorable single judge also. In fact, he reflected entire my submission, not that he ignored any submissions of mine.
All right.
But what happened, Lordship, kindly say, Annex 1, Lordship, kindly say.
Kindly, sir, with your kind permission, I would like to read the single judge.
Sorry, sir.
Yes.
Yes.
Please take me to the judgment of the learned single judge.
Yes, then, yes. The judgment. The judgment, my lord, in the judgment is a page 170, 78, 79, 80. It's starting from 80, my lord. 80.
Page 95, that issue has been filed.
Yes, I'm coming. Issue has been 2 issues honorable single judge has issued. So, my lord, what happened? From the first line, the petitioners in all these representations are the employees of the Orissa Renewable Energy, and they are approached this honorable seeking for a common relief. All these writ application, all these respondents are common relief. Let's kindly see. Page 95, na? Yes. Let's kindly see the page. Question consider. So can listen page 94.
Yes.
Page 94, paragraph 10.
Yes.
103. 2 issues on the above factual background of the case. The following questions emerge in the consideration: whether Orissa is a PSU, and if so, whether resolution dated 2/8/2014. That means P department resolution of the government in public interest departments applicable to it. Then whether the petition should be extended with the benefit of retirement age from 58 to 68 years, are par with their counterparts in similar situated organizations under the administrative control of the Science and Technology Department. So then if so, what relief? So with regard to this, my lord, issue number 1, also can see my date chart. In my date chart, because for your lordship's convenient, exact 2 to 3 documents I annexed, and also in the honorable single judge, I submitted entire documents, my lord. Lordship, kindly see. Page 8, lordship, kindly see my date chart.
Yes.
Page 8 of my date chart. That was all are also in the single judge file. Page 8. এটা কোড কো দেওয়ার কথা ছিল আমি বলছি ওইটা আমার so can you see page 8
page 8 you kindly read there on page 8.
Yes, I'm ready. I'm sorry, madam. In the page 8, it is the government of Orissa Science and Technology Department's letter to the chief executive Orissa. Also, can you see what they said? clarification of status of Orida. Information required in WPC number such and such, Digambar, whereas it's the first case, because all cases are tagged under the first case. Inviting reference to letter number such and such, the subject letter, I am directed in from the Orida is an agency registered under the Society of Registration Act. It is a non-profit making organization of functioning under the administrative control of the Science and Technology Department with the financial assistance in shape of granting it. Further, it is to intimate to that serial number 5 applicability of the guidelines of corporate government's manual. The manual is there also. Now, state PSUs of Department Public Enterprise Department as follows. The guidelines will apply to statutory corporations, including PSUs registered under the Companies Act, which the government of Orissa holds 51% or more the share capital. The guidelines are also applicable to Orissa Industrial Infrastructure Development Corporation, IDCO. Hence, Orissa is not a public sector undertaking under the government of Orissa and also not coming under the principle of Department of Public Enterprises. This is for your kind information and necessary action. Honorable single judge wanted some clarifications in the midst of hearing. That is why this letter was issued. Then subsequently also can to page 9, next page. I'm sorry, next page. The next page. That is that piece of letter also, that is the government's counter. Government's counter.
So how does the single judge deal with this? Let us see that.
Honorable single judge, he said that in fact, whatever it may be, but the Orissa is.
Let us read how he deals with it.
Yes. Yes. Question number 1. 11.1, page 95.
Yes.
These letters, my lord, in fact, he referred. He ignored these letters, my lord, honorable single judge. I may be obliged to, because he referred all of my submissions. But he said, specifically, see, this is a very big paragraph. Admittedly, Orissa has been registered under the Society of Registration Act, and it is a very society. The memorandum of association clearly indicates the clause 3 objectives. The objective mentions clause A, such and such, the exist identities shall kennel hands also relevant. Section 861E of the the referred Electricity Act, my lord. Then subsequently the objective opposite part number 3, such and such, and the provisions of contained in section 86(1)(6) of the Electricity Act, as referred to above, clearly state that the nature of duty of discharge by it is a public utility service. Honorable Singh just said that it is a public utility service, my lord. As it is indulged in generation of power, my lord, that is not a profit-making organization. They show it, my lord. It is clearly mentioned by the.
Kindly read. I am not able to have the continuous commentary, sir.
I'm sorry.
When I read a paragraph, I'd like to read it fully, if you don't mind.
No, I'm sorry. No, I'm extremely sorry. I'm extremely sorry. I apply it because
no problem, sir. Read it, sir.
Then
kindly read it continuously now. The objective of the opposite party,
yes,
number 3.
The objective of opposite party number 3, vis-a-vis the provisions contained in under section 86(1)(6) of the Electricity Act 2003, as referred to above, clearly states that the nature of duty discharged by it is a public utility service, as it is indulged in generation of power through that is mini micro hydro projects with a view to augmenting the energy sources of the state and for making power available in the rural areas. To stop. Once it is indulged in public utility service, it is discharging public functions. A body is performing public function when it seeks to achieve some collective benefit for the public or a section of public and is accepted by the public or that section of the public as having authority to do so. Bodies therefore exercising public functions when they intervene or participate in social or economic affairs in the public interest. Then body is performing
Yes.
Then 11.2, Honorable Single Judge referred a judgment, that is such and such, my lord. Then 11, a body is performing a public function when it seeks to achieve some collective benefit for the public or a section of the public and is accepted by the public or that section of the public as having authority to do so. Full bodies therefore exercise public functions when they intervene or participate in social or economic affairs in the public interest. This may happen in a wide variety of ways. For instance, a body is performing a public function when it provides public goods or other collective services such as health care, education, and personal social services from funds raised by taxation, full stop. A body may perform public functions in the form of adjudicating services such as those of criminal and civil court and tribunal system. They also do so if they regulate commercial and professional activities to ensure compliance with proper standards. For all these purposes, a range of legal and administrative technique may be deployed, including rule making, adjudication, and other forms of dispute resolution, inspection, and licensing. Then 11.3. In Hindustan Zinc Limited, the Apex Court held that a regulation framed by Rajasthan Electricity Regulatory Commission in excess of power on section 86(1)(e), read with section 181 of the Electricity Act, provides for promotion and
just read 11.12 now.
11.12, my lord. 11.12. Yes. Yes, my lord. Yes. In view of such position, Orissa may not be classified as a PSU as has been notified by government. But yes, my lord, I'm obliged, my lord. That is why
kindly read the whole thing.
Looking at the functioning, it can be safely inferred that it has all characteristics of PSU and is discharging the public utility services for the benefit of public at large. If the functioning of Orissa is taken into functioning of statutory
akin to functioning.
Orissa is akin to functioning of statutory PSUs and is discharging the public utility services, even though it has not been enlisted or notified as a PSU of government, taking into consideration the characteristics of its functioning. An inference can be drawn that since it functions for the benefit of public at large and the administrative control lies with the state government, the rules and regulations applicable to the state government employees and its PSUs are also applicable to it. That is the finding of the Honorable Single Judge, my lord.
So there is no discussion of these two documents.
Exactly, my lord. Exactly.
No, but did you place these documents?
Yes, my lord. Yes, all these things are there in the ordinance.
No, all these things are there means you annexed it with your reply.
Yes, my lord. What happened, my lord? Original case that is 8493, that is rate of fill. In a rate of 305/2017. First case was the matter was argued at length. Then lawsuit can see that if the judgment, in the judgment they referred this. All these things are covered because same players are there. So that one case is argued.
No, my question to you is something else, sir.
In this
which you have shown with your date chart, you enclosed two documents.
Yes.
Were these two documents before the single judge?
Yes, my lord. Yes.
You had placed it with your counter affidavit.
Yes, my lord. The counter affidavit also placed in a note of submission also placed, and also honorable court brought the entire file from the government, my lord.
I see. All right.
And that is also state government counter, my lord.
All right. Yes, Mr. Rathur.
Your lordships, let me answer this point. Your lordships, how did the court actually come to this finding of PSU? That's very important because some paragraphs were actually skipped. Your lordships, actually, when we come to the term of public sector undertaking, this is not really a defined term somewhere. Your lordships, that's exactly what 11.11 discusses. Taking note of the Supreme Court judgment, what the court really has said in those judgments, what they are actually interpreting a public sector undertaking means it has to be a company or a commercial venture where either the 100% control or 50% control. That's what is the clarification.
If you're borrowing from 11.10, just see what the single judge notes in 11.10.
allow me to read 11 point. I think your lordships are very clear about the public utility service. I think don't need to go to that aspect of that judgment. 11.10.
But let's just come to 11.1.
Yes, your lordships, 11.10. Now coming to the concept of public sector undertaking, explanation section 2.1.2 of the Building and Other Construction Regulation and Employment Condition Act states that public sector undertaking means any corporation established by or under the central, state, provincial act or government company as defined as 617, the Companies Act, which is owned, controlled, managed by the central government. Except this, there is no other meaning of public sector undertaking prescribed anyway. But your lordships, 11.11 is the main thing. Meaning of public sector undertaking had come up in the consideration of Leelabai Ganjana and Pansare. In paragraph 63, 64, 65, the judgment of the apex court observed as follows. Your lordships, may I be permitted to place the entire thing? One point may be noted at this stage: the concept of PSU and concept of government company became relevant after the introduction of economic reforms in 1991. When the said reforms, market orientation was given to our economy. It is around this time that the role of important. Both the PSU as well as the government company were given autonomy and flexibility in commercial sectors. Annexure 1 of the report, the study team, the PSU dated 10/6/1967 indicates clearly government companies stood cover under the concept of PSU. In the present matter, the High Court has taken a view that the government companies stand excluded from PSUs under section 3(1)(b) of the government companies are separate and distinct entities from PSU. And since the government company is not enumerated items in section 3(1)(b), one cannot include said entity within the meaning of PSU. This view of the High Court is erroneous for the simple reason that the word PSU is not defined under any act. The word PSU is indicated in various parliamentary committees in administrative reforms, so that in financial employment and in policy matters, the central state government could evolve norms and standards. It is no doubt true that public character of the function performed by the undertakings determine the character of that undertaking. It is public character of the functions of the undertaking which makes it a PSU. However, there is no conclusive test for determining the status of an undertaking as a PSU. In judging the character of an entity, I'll emphasize the word entity, the word has to be kept in mind the context in which the word PSU is used in a given enactment. There are a number of tests which could be applied in judging the character of an entity, namely the test of origin, the test of agency, instrumentality of state, the functional test, the monopolistic status of an entity, test concerning areas of operation, the test of economies of scale, test of control, the role of the entity in the priority sector. Therefore, there is no one conclusive test applicable to decide the character of an entity. For example, the nationalized banks have been held within the meaning of state by the court on an application of test of control. Similarly, the test of agency and instrumentality that came to be laid down brought the government companies as defined under section 617 of 1956 Act to be included within the concept of state for the purpose of Article 12 of the Constitution. Therefore, none of the above tests is conclusive by itself. Suffice to say that the government companies under section 617 are understood by the legislature to be part of PSUs. Therefore, even on the website of central government undertakings, under the caption of PSUs, PSEs, we find government companies and state-owned companies being listed under the caption of PSU and PSE. These items have been enumerated on the basis of legislative understanding. The next portion is very important. According to the book titled Growth of Trade and Commerce in PSUs, written by Shri Suresh Prasad Padhi, PSUs may be in the form of a departmental units, corporations, government companies, autonomous body authorities. Corporate governance, according to Geeta Gauri, is one of the major process of putting PSEs and PSUs on the right track. In the list of PSUs established on the website of central government, BPCL is also known as a PSU. Similarly, MTNL, BSNL are government companies which are shown as PSUs. Then comes the single judge finding. In view of the law laid down by the apex court, as discussed above, it is no doubt true that the public character of the function performed by the undertaking determines the character of the undertaking. It is public character of the functions that the undertaking which makes it a PSU. PSU may be in form of a departmental units, corporation, government companies, autonomous bodies and authorities. All the important forms of organizations of the PSUs have certain advantages and certain limitations. Majority of PSUs in this form has been mainly that of autonomy. Similar in the case of statutory corporation, which is also created to mitigate drawbacks of departmental administration. Your Lordship, may I be allowed to submit here? PSU is actually a very broad term.
No, one thing, just tell me, there are two documents here. I know, you just finished this. There is a document that has been placed before us. Was this document before the single judge?
Yes, Lordship, kindly 11.
1 minute, sir. I'm just having a question to her, if you don't mind.
No, sorry. No, sorry. Honorable the single judge.
Sir, I have asked her a question. I want her to answer it.
Lordships. I don't find that from the counter. But I also admit that I was not the counsel before the single.
So this is very crucial. I'll tell you why. See,
yes.
The judgment that's been referred to, the short question in that judgment was whether a government company, which is 100% owned, can be a PSU.
Lordships.
That was a short question. So in Gajanan Pansare, the court answered, Supreme Court said, yes, there are so many 100% government companies which are classified as PSUs. We don't see any reason why this particular government company can't be a PSU. So the ratio is that. The ratio is not whether a society can be considered to be a PSU. And in doing that, if the government of Orissa has a certain understanding of what it considers to be a PSU, the court may agree or not agree with it, but the court cannot avoid discussing.
Your Lordships, let me submit that, Your Lordships. In fact, this entire issue that whether it's a PSU or not is actually irrelevant for determining the final relief. That is my first submission. In fact, I should have said this before this came up actually. The reason first is, Your Lordships will see, admittedly, this is a registered society. I don't disagree. This is under the energy department. No disagreement. It deals with renewable energy, completely controlled by the department, completely financed by the department. Mm-hmm. That this particular agency, in its 10th resolution, had said whatever are the service conditions of the government of Odisha employees will automatically apply to us. So this was the understanding of the employees. The moment the Odisha government took a decision on 28/6/2014, Orissa was under its obligation to complete all this administrative work. So these people automatically get that benefit. What did Orissa do? Sit for 2 years. Sit for 2 years. And this is not the first case, Your Lordships.
And we will continue.
Justice A.K. Ratha's judgment was in place, where they already had lost the battle.
So you tell us first what these two documents.
Lordships. No,
one issue framed by the single judge is whether it's a PSU or not. So we can't avoid answering that. That is an issue. One has to address that. And the sequence of arguments before the single judge seemed to be that once you say it is a PSU, then the question arises whether the age increase applies to it or not.
No, Your Lordships, while answering the second issue also, definitely single judge has taken note of this first issue, but has also said that the entitlement had already been decided.
But we'll have to deal with all these
issues. One, by the High Court itself, and you didn't challenge it. Second, by your own resolutions, you had already decided to do it. Why did you stop? That's the second issue which it went to decide, Your Lordships. And today, Your Lordships, because
we'll continue tomorrow. We'll continue tomorrow.
And because of stay order, Your Lordships, today they are only going to get is this pensionary enhancement only, refixation of pension actually, nothing more.
All right, let's see.
I mean, I'll also find out whether they actually had submitted.
No, I don't know if after this judgment they're retiring at 60 now, is it?
Yes.
No.
What happened?
The present petitioners did not get the benefit.
No. What about the later?
Yes, Your Lordships. They have implemented the prior High Court judgments also on this point. There was one more candidate called Sushant Kumar Das who continued by the order and he got the benefit even before the amendment.
So it's only these 10 employees who are not getting it.
Exactly, Your Lordship. Similarly placed. The only unfortunate is they did not have a stay order. Those people have stay order. In principle, they have accepted it. They initiated the movement.
So
but
today your employees are retiring at 60.
Yes, we allowed. And that is the date is, my lord. Date. Let's see. That is in 33/2016.
So what is the big advantage for 10 people you are depriving them?
No, not 10 people. What happened? Let it come in other days.
No, how many such people are there? Like
Yes, total,
the
I think
respondents before us.
What happened if this will be allowed, the judgment will allow, my lord, not only from Orissa, my lord, in other corporations also they are voting. What happened, my lord? Public Enterprises Department, in fact,
the appellant before us is Orissa, right?
Appellant before us is Orissa. What happened?
So we have to only deal with Orissa.
Yes, the public.
We don't have to deal with other corporations.
That is correct, my lord. Subsequent, I mean, what happened, my lord? Public Enterprises Department very notification doesn't say that it will ipso facto applicable to the state government's.
That is a point on merits. I'm asking on facts, please.
15 to 16.
No, all of your employees are today retiring at 60.
Yes.
So how many such employees are there who are similar to the ones before us?
That I'll examine.
8, your lordships. I think that's there in page 6 shows
yes.
8.
Similarly, exactly for you, when you retire.
No, the ones who came before the court and succeeded,
yes,
they are the ones in whose cases you filed appeals.
That's correct.
How many such employees are there?
Similarly placed.
Who succeeded before the single judge in their plea that their retirement age should be 60. How many such employees are there?
In the list there, I'm coming, right? In the very list, my lord, how many persons are there? 1, 2, 3, 4, 5, 6, 8, 6, 7, 8, and 9, 10, 11 persons are there.
All right. Apart from these 11, there is no one.
No one.
So only for 11 persons, all you have to do today is they cannot come back to service. They must have crossed 60.
No.
So it's only question of monetary benefits.
No, because Lordship's judgment is Honorable Singh's judgment is they should go back. Suppose it's a retired particular date. They'll go back, relate back to that 60 years. That means they'll get entire service benefit and also the entire. That's the whole problem.
They anyway have to get. Instead of getting at 58, they would have got it at 60.
No.
There's no promotion, nothing. It's only salary.
No promotion. Promotion is nothing.
And no salary because only pension. Only pension. There's not even a salary. No arrears of salary.
No, nothing.
Only pension.
Your lordship, that's also clarified in the relief portion. The court says the petitioner who have approached the court after retirement or attending the age of superannuation and in the meantime had attended the age of 60 years shall not be entitled to arrear of salaries. However, they will be deemed to be continuing in service up to the age of 60. In their case, the Orissa shall treat the age of superannuation as 60 years and fix the pay accordingly and refix the retirement benefits like pension gratuity on such calculation.
So that's fair enough, sir. It's only about pension.
Yes. And
nothing more.
All those who could have got the benefit
increase the age of retirement. All this is academic. Why should we now break our heads on whether 60 applies to you or not?
No, not that way. What happened, my lord? In this particular case, rule is, my lord, that it will be 50 to 60 years. That has not been amended. In the very rule, it says that after amendment, that can be extended. So what happened, my lord? Here, the Orissa Renewable Energy took a decision on 12/3/2015. I also asked my learned sister about that. On 12/3/2015, board has taken a decision. So that was suggestion. 12/3/2015, board has taken decision. The rule says that unless authorized that 58 is the date of superannuation.
All your arguments, even if you keep it on one side, the fact remains they're all going to get some enhanced pension, nothing more. Substantially prejudicial to you, which is going to affect all your future cases, nothing like that.
Not that way, but there is something there. Let it come tomorrow so that I'll discuss with officer. Day after tomorrow.
Your lordships, there's nothing really. Only refixation of pension, your lordships. No relief we are going to get. Nothing we are going to take from them.
It is because at the instance of state government, in fact, we did it because not that our.
No, if there is some serious prejudice going to be caused to you, one can understand. There's no prejudice going to be caused to
Because
you.
in that aspect, my lord, kindly give some breathing space. Otherwise, my lord, because it's.
No, your only Orida has come before us. No,
Yes, I'm concerned to Orida, because I'm appearing for Orida.
That's right. So I'm saying we're only talking Orida, we're not talking anybody else.
Yes. Let it come in.
And in already in Sushant Kumar Das case,
that is
which
not-
is Justice A.K. Ratha's judgment for the same Orida,
No, that is
your
not
lordship, in
applicable.
that case, that person was supposed to retire at 58. He then was retained in service. He's taken all the salary and also enhanced pension. You never challenged that judgment. That's also discussed. Your
That
lordship.
very day he retired, madam, 31st.
Yes, but
2016 he retired. But that means government also decided the date of superannuation that date. So naturally, Orida adapted that. So naturally, got the.
I mean, but in principle, that judgment was staring at you, and you never decided that. And anyways, if goes into the basic matter, then you sat over the matter for 2 years for doing nothing.
So it means
And today, what are we getting? Only pension.
That is why I said when the Orida governing body took a decision from that date, you can no problem.
We'll see that actually there's no question of law also to be left open because you have anyway accepted the principle. You've accepted the principle, you've enhanced the retirement age. All your employees today are retiring at 60.
Yes.
So we'll explain that. We don't think we'll interfere. All right.
And the very notification which your lordships they are saying that is not applicable, that very notification they used it to implement.
No, we can
They
only
sent
say
everything
that
according to that.
we'll only clarify that every autonomous body which is similarly placed, the question whether it's a PSU will be decided afresh irrespective of this.
Yes, that question may be kept
left open. That question will leave open.
Lordships.
All right. The writ appeals are disposed of. I'll pass the detailed order.
So far as the next sub-items, my lord, the next sub-item, my lord, writ appeal number 274 of 2017. The next sub-item, my lord.
Tell us, please, tell us.
Yes, my lord.
They also filed,
There, my lord, we have challenged the judgment, my lord, only on one point, my lord. So far as the relief is concerned, relief number 2, my lord, only to that extent, my lord, this appellant is agreed.
Place cause of action.
Place, my lord. Very internal page 38.
Yes.
Judgment of the Honorable Single Judge.
Yes.
Lord, I am aggrieved by relief number B, my lord. The petitioners who had approached this court after retirement on attaining the age of superannuation and in the meantime have attained the age of 60 years shall not be entitled for arrears of salary. Lord, my humble submission would be this is contrary to the judgment of the Honorable Apex Court in the year 2013, which has also been taken note of. I will place that judgment, my lord.
Separate cause of action.
This is the judgment of the Honorable Apex Court, my lord. Specifically stated that no work, no pay will not be applicable so far as this case is concerned, and they will be entitled to.
That is because they had a previous round of litigation there.
Yes, yes, my lord.
There was a history of litigation in UP Jal Nigam.
Lord, yes, my lord. After 58 years.
No, there was a history of litigation earlier. There's a whole round of litigation of UP Jal Nigam after the Supreme Court. That's why they're saying that.
Yes, my lord. No, specifically, that has been taken note in the single judge, my lord. But while granting the relief, my lord.
Here, there is no previous round of litigation, please. There was no compulsion on them to grant you an increase in age. It is only because of a policy change they made for state government employees that this question arose at all.
Yes, my lord. May I place, my lord? May I place, my lord? The last page, my lord. Paragraph number 38, my lord.
Yes.
Lord, in these cases, as we have already held, that regulation 38 shall be applicable and the age of superannuation of employees of Nigam shall be 60 years. Lord, the next portion is important.
Yes.
We are of the view that following consequential and pecuniary benefits should be allowed to different sets of employees who were ordered to retire at the age of 58 years.
Yes.
Lord, the first one, Lord. A, the employees, including respondents who moved before a court of law, irrespective of the fact whether interim order was passed.
When did they move is the question, sir. Not before, after the retirement.
Lord, here, yes, Lord. Lord, I will take, my lord, to the previous paragraph. Lord, it has been discussed, my lord. Lord, once, my lord, I am not allowed to work, my lord. I approached the Honorable Court, my lord. It is after that, my lord, that has been taken note of in the previous paragraph, my lord.
Yes.
Starting for paragraph number 33.
Yes.
the single judge.
No.
Yes.
Read.
Starting from paragraph number 33, my lord, may I please?
All right.
And now the question arises as to what consequential benefits to which the respondents and other employees who have not moved before any court of law shall be entitled. But by the impugned judgment, the High Court observed so and so, my lord. I will take, my lord, to the relevant portion, my lord. Admittedly, these employees have not worked. So on the basis of no work, no pay, no work, they will not be entitled for arrears. However, their back wages will be restricted at the rate of 20% of the basic salary as per the ratio laid down in the case of so and so, my lord. It is clarified that the extended service will be counted for all purpose to the above mentioned employees. The petitions are allowed no cost. But then, my lord, paragraph 34. In the case of so and so, my lord, this court, while allowing the employees till the age of 60 years in view of regulation 31, ordered that no recovery shall be made from those who continued up to the age of 60 years. This court further observed that the employees who have not been allowed to continue after completing the age of 58 years by virtue of erroneous decision taken by the Nigam for no fault of theirs would also be entitled to payment of salary for the remaining period up to the age of 60 years. But I harp on this, my lord. But this, after this, my lord, then my lords may kindly come to paragraph number 37. In view of the orders passed by this court in so and so case, my lord, it was not open to the High Court to rely on
that case.
Yes,
you're just picking up all the paragraphs that are convenient to your argument, correct?
Yes.
You have started reading from para 33 because it is convenient for your argument. What I tried to tell you even earlier, if you come to para 8, there is a whole round of litigation concerning this very issue in the Supreme Court from the year 2006 onwards.
Yes, true.
It is in that context that they are saying that this employer knew that they were creating two different categories and therefore they don't want to discriminate. So this judgment is not going to help you, sir. Because there are two rounds of litigation in the Supreme Court concerning this very employees. In your case, there is no second round of litigation. This is the first time you have come to the court.
But I bow down, my lord.
Sorry, we are not agreeing with you on this. We dismiss that appeal.
Take the advantage of that.
Sorry, we don't agree with you. Dismiss this appeal, and the other appeals are disposed of, clarifying that every case would be decided on its own peculiar facts.
All right, my lord.
All right. All right.
Lord, may it please your lordships.
Yes,
Item
please.
number 1. My lord, would your lordships kindly come to page 3701 of the writ petition, my lords, 3115 of 2020. That's the lead matter. Three 370. Lord, your lordships have it, my lord?
3992.
My lord, this is the deed, transfer deed, P17, page 370.
WPC 3115 of 2021. Will my lords have it?
1 minute, please.
I'm so sorry. My apologies.
So you're referring to the lease deed? 14th
My lord, I'm referring to tripartite transfer of mining lease Form O.
22nd June.
Deeply obliged. Grateful. My lord, if your lordship sees, my lord, this is 22nd day of June 2006.
Yes.
Between the first party is the Sarda family, my lord, Sundarlal Sarda, Monlal Sarda, transferor over the page.
Yes.
And my lord, the other party is Sarda Mines Private Limited.
Right.
So both have their successors and interests defined. Here, Sarda Mines is the principal, so is the Mohanlal Sarda and Sundarlal Sarda.
Right.
So, my lord, therefore, they are not the same person. Obviously, not because there wouldn't have been a transfer otherwise. What is more important is foot of the page 371. The lease deed is clearly clarified. 14th August 2001. I had shown it to your lordship's lord at the cost of repetition. And it says page 155 to 234, serial number so and so. My lords, may kindly come to 372. Lord, what I failed to show your lordships is what was the tenure of this agreement. And that your lordships will get in the second para of 372, whereas the transfer is now desirous of transferring and assigning the lease to the transferee, and the state government has, at the request of the transferor, granted with prior approval of so and so permission to the transferor with the order date number 8762 dated 7th June 2006. Now, this is critical. So therefore, by incorporation, the period is there, and that your lordships will see at 369. At 367, this letter of 7/6/2006, your lordships will file at 367.
Yes, that's the previous
It says for the unexpired period of the said lease. My lords have noted it on the last time, lords.
Right.
So therefore, this tripartite deed also refers to the tenure of this agreement. Am I clear, lords?
Yes.
If your lordship now turn to 374,
yes,
there is a Roman 4. My lords have it, lords?
Yes.
The transferee hereby declares that he has accepted all the conditions and liabilities which the transferor was having in respect of such binding lease. So that is the lease dated 14th of August 2001.
Right.
Am I clear, Manoj?
Right.
And kindly see the last paragraph. The other day I had shown to your lordship section 6, where there was a restriction on the area to be held by a lessee. The transferee hereby further declares that as a consequence of this transfer, the total area while held by him under mineral concessions are not in contravention of section 6. My lords have it, my lords?
Yes.
Section 6 said less than 10 square kilometers. And I had shown to your lordship that day, my lord, 10 square kilometers is 2471 acres. And lease is 2340 acres.
Right. That Thakurani A and Thakurani B.
Lordship pleases, grateful.
Right.
Now, my lord, that is one submission of mine. Now, kindly see, my lord, section 8, as it stood when Justice Hansaria passed the first judgment. And that your lordships will get at, my lords, page 241 of volume 2. Your lordship, I will not trouble your lordships with that. Your lordships may only note, my lord, 8-2 at that time was 2 tenures of 10 each. So it was 20 years.
Right.
Your Lordship may only note it is available at page 241 of volume 2. But I will not trouble your Lordships with that. Let us straight away come to to that same volume your Lordships are holding 3115. Kindly come to page 177. 177. My lord, 8-2 at the relevant time was 20 years. Kindly now come to 176 and see what is the highest the case of the petitioners can be. Does my lord have page 176? My lord, writ petition page 176.
Yes, 1 minute, please.
I'm sorry. My lord, say 176.
176 of the second writ petition.
No, the first, we are only on the first writ petition, 3115 of 2021. The volume which your Lordships are just now seeing.
Yes, yes, 1 minute.
I will only take your Lordships to this petition only, not the second.
All right, 1 minute. Yeah, correct.
Yeah. So therefore, my lords, assume there was no compromise.
Right.
Assume there was no modification.
Right.
Assume there was no transfer.
Right.
So what your Lordships gave is this. Let me read this. We therefore modify our order only in one regard. The same is that instead of renewal, kindly note, my lord, renewal for 30 years at a time, the same would be for 20 years. To start with, which period shall be extended by 10 years. That 120 is a typo. Without any further action or step being taken by the leaseholder and without requiring any fresh order of any authority in this regard. My lord, would your Lordship read the next line? This is very critical. The renewal for a further period of 10 years would be without any break. So what the mandamus was that there has to be a further renewal for 10 years. That's the point, Mills.
Right.
Now see 8A4 as amended in 2015. So, my lord, therefore, this judgment says that as and when the lease comes to an end, a further renewal of 10 years without any break.
Right.
If your Lordship now, the law as it stands today, section 8, capital A4.
Yes.
What happens on the expiry of the lease period? Kindly see 8A4. On the expiry of the lease period.
Yes.
The lease shall be put up for auction as per the procedures prescribed under this Act. My lords have it, minutes?
Yes, yes.
And kindly see the previous page, section 8. Periods for which mining leases may be granted or renewed. The provisions of this section shall apply to minerals specified in Part A of the first schedule. So therefore, coal and lignite, no iron ore. So therefore, my lords, the first judgment says that when 20 years are over, you will get a further renewal of 10 years.
Right.
Now, the concept of renewal has been done away under law by the amendment in 2015. It says the renewal provision limits it to coal and lignite. 8A says once the lease comes to an end, it has to go for auction. So therefore, my lords, by legislative intent, assume this judgment was there without being modified. Assume the parties were the same. by legislative intent, the mandamus stands effaced. In other words, my lords, the petitioner seeks the mandamus, which is contrary to the law as it stands today. My lord, there is one more, your lordship may only note para 29 of Justice Kehar's judgment, which is at page 250 to 278 of volume 2. I will not read it. I've read it the other day. They also say that there is no renewal after the 2015 amendment. I will rest it at that. Now, my lord, I have given a small list of dates, which is called volume 1. My lord, before that, let me finish this writ petition volume so that I will not trouble your lordship back again. My lord, would your lordship see page? No, my lord, your lordship may come to my volume 1, which is a note I have given.
This one.
And there is a page towards the end, which is page 111HH. It should be the volume 111H.
Yes.
Lordship may see para 189, where Justice Lokur has called out how section 6 was at different periods of time. Your lordships will see page 1, para 189, 1658 to 11972, maximum area was 10 square kilometers. My lordships have it, my lords?
Yes.
And from thereafter, it has always been 10 square kilometers.
Right.
So therefore, right through the proceedings, the maximum area somebody can hold is 10 square kilometers. Now, my lord, would your lordships kindly see, my lord, the state government had written to the Saradas that you are holding more than 6 kilometers, and that your lordships will get at page 509 of the writ petition, my lords. That will be volume 2 of 3115. My lords have it.
1 minute.
Sorry.
Six five five. Got it. Yes.
509, my lord, para 128. This is a part of the CC report, my lords.
Right.
So the middle of the paragraph, accordingly, a notice was issued directing BN Sarda to relinquish the excess area so as to enable the state government to act upon the direction of central government. Only to show, my lords, that they were put to notice that you are holding more than 10 square kilometers. So that completes my 6(1)B argument, my lords. Now, my lord, your lordship may see my list of dates, which is in volume 1. Just a couple of dates. My lords have it?
Yes.
Page 15, serial number 25.
(1993).
Lordship pleases. My lord, state files as SLP And kindly see 4495. 4495, serial 26. A division bench of this High Court holds, interprets section 8.3 and holds, the statute itself requires an authority to record reasons. The reasons have to be recorded by the authority itself after applying its own mind, and it cannot be presumed that it has adopted the reasons given by another authority. So your lordships hold that for granting a reasons have to be recorded, and that 8.3 is quoted at page 15, just the page before. My lords have lords?
Yes.
Notwithstanding anything contained in subsection 2, if the central government is of opinion in the interest of mineral development, it is necessary to do so. It may, for reasons to be recorded, authorize the renewal of a mining lease for a further periods not exceeding, in each case, the period for which the mining lease was granted. So your lordships interpret on 4th of April 1995 that when you grant a renewal under 8.3, you must record reasons. And the judgment in question, my lord, did not render any reasons. And therefore, my lord, this judgment was rendered by Justice Chatterjee and Justice R.K. Patra. And on 21/9/96, my lords, while the SLP was pending, this judgment was confirmed by the Honorable Supreme Court, and your lordships will get it at serial 28, page 17. Paragraph 34, my lord, to the middle. Ordinarily, a lease is not to be granted beyond the time and the number of periods mentioned in subclauses 1 and 2. If, however, central government is of the view that to allow the lessee's lease to be renewed further, it would be in the interest of mineral empowered to do so, provided there exists on record sound reasons for such action, and those reasons are recorded. Since such a measure has been incorporated in the legislative scheme, a safeguard against arbitrariness, letter and spirit in law must be adhered in a strict manner. Your lordship, I will not trouble your lordships anything more. The next page will say that this judgment has been followed in Goa Foundation. Now, my lord, what happens is, while these two judgments come, my SLP is still pending before the Supreme Court, and this is when serial 29, page 19 becomes important. So here, the Saradas realize that they can't hold an area beyond 10 square kilometers. 8.3 stands interpreted, and therefore they file an application for modification of your lordship's judgment on 5/2/1998. It is not as if it was a win-win situation for both the parties. On the contrary, my lords, 8.3 stood interpreted, and they could not hold an area beyond 10 square kilometers. And now your lordship, page 22, serial number 31. My lord, this is the compromise that this honorable court noted in the modification application filed by the Saradas, not the petitioners, the Saradas then, my lords, while the matter was pending before the Honorable Supreme Court. My lord, I have called out a few paragraphs. Your lordship may straight away come to page 23, paragraph 12.
Yes.
We find expressly there is merit in the contention of learned counsel for the respective parties. Certainly, this court cannot pass any order accepting the terms of compromise so far as matters pending before the apex court, but certainly take notice of all the events relevant for disposal of the present writ application, and the matter thereafter can be referred to the apex court for disposal of matters pending there. What is very relevant is the last paragraph. It is also recorded this compromise, if effected to avoid all controversies between the parties and also to shorten litigation, it is intended as also contended by the claim for renewal of mining lease in respect of block A is abandoned to enable state of Orissa to deal with the block for consumption by others. And so far as block B is concerned, will be renewed for 30 years from the date of renewal, taken such a stand for the benefit of the state itself and also for the benefit of other parties. Kindly note, not very important, as law permits. I am emphasizing on the last two words, as law permits. I'll tell you lordships why. because by then Justice Chatterjee has already rendered his judgment on 4/4/91 interpreting section 8(3).
Right.
Lord, am I clear, my lords?
Yes, yes.
Now, therefore, my lord, compromise is qualified with as law permits. Now, my lord, today, the lease, if auctioned, the state will be entitled to royalty, district mineral fund, NMET, and auction premium under the new regime. Now, my lord, there is this, my lord, your lordship must have been handed over the propositions I wish to submit, my lords. My lord, I will quickly take 2 minutes, run through this, and then conclude. My lord, my first submission is no amendments against statutory provisions. Rights are confined to the acts and rules made thereunder. I will give your lordships a note of submissions.
Right.
Importance of statutory lease deed, rights and obligations of the lessee flow from the lease deed. All rights vested under a settlement or a compromise will always be superseded by an amending law. Compromise recorded by court does not render the issue res judicata since there was no adjudication. Whereas subsequent to a decision rendered by a court, the law has been changed, the earlier decision will not operate as res judicata. Subsequent change in law has rendered decrees inexecutable. Existing date of decision shall be applicable, and waiver by conduct. Writ may be denied, although a clear right thereto is established in public interest will suffer, and without interpretation of section 8(3). I will give my written submissions on this and the judgments. In conclusion, my submission is this: the Saradas are not before your lordships. The rights of the present petitioners are circumscribed by the tripartite lease deed and the order dated 7/6/2006. Even otherwise, assuming that the judgment of 18/12/91 of Justice Ansaria, the first judgment of your lordships, was required to be implemented, even then, the direction was for a further renewal of 10 years. Pertinently, it is the erstwhile lessee was approached this court seeking to modify the judgment of 18 December 1991 during pendency of the civil appeals. The same way, for the reasons that the Honorable Supreme Court had laid down the correct law under 8(3) in Tisco's case, and by virtue of 6(1)(b), the Saradas could not keep both areas. Notably, Saradas left Thakurani A because the same itself exceeded 10 square kilometers. The second judgment of the High Court, which only records the compromise and not a decision with the caveat as law permits. So, in my humble submission, my lord, writ petition is liable to be dismissed. And so far as the second writ petition is concerned, that is a fallout of the orders passed by the CEC, which is there in the writ petition itself. But in the event the first writ petition is dismissed, then all others follow. I am grateful to your lordship for a very patient.
Right, right.
Well, this, when would your lordships now, should you want me to start my reply today, or Malats, would your lordships want to do it in one go?
No. Whatever suits you, Mr. Sibyl. If you want to do it on another day.
I have a parted at 4 o'clock, Malats.
Okay. Then we'll have it on some other day. Not an issue. Then can we put it to next Monday?
I can, Malats, just give your lordships a bird's eye view for 5-7 minutes. Can I, Malats?
All right. And then next Monday?
And then next on the 26th, if it's possible, Malats. 26th is a Friday.
No, that won't be convenient for me. So Monday is better. Monday afternoon is better.
Monday, then I have some matters, no? 29.
Even 30th?
Can it be the following Friday then, Malats?
Which would be 3rd December.
Yes.
3rd December. Huh? Or 21st, 21. The only difficulty in Fridays is sometimes there's a reference and all that, then it all goes for a toss. So Thursday might be a better option then. Will second be all right?
29th. The 29th, I'm already.
Second is okay, sir.
2nd December?
But it's Thursday.
Yeah, 2nd December, 3 o'clock.
Very well, very well. I'll just give you a bird's eye view, Malad, so that your lordship knows what the focus is going to be.
All right.
Malad, remember, this is not a lease that is executed, Malad. It was a lease executed in 1934.
Right.
And Malad, there was an automatic renewal for 30 years. In other words, the lease was for 60 years. 30 years at the inception, 30 years automatic renewal. You can never forget that. Now, Malads, at the end of the first 30 years, an application was filed for the purposes of its renewal in terms of the lease itself. Unfortunately, in between, Malads, several events occurred, including the central government reserving it for the public sector. So the lease could not be renewed. Thereafter, Malads, when the central government passed an order directing the state government that no, now we give you approval in 1968. Note that date. In 1968, the central government granted approval of extension, approval for another 30 years. And told the state government to execute it. State government said, we have reserved it for the public sector. So that didn't happen. Ultimately, Malads, we went to court, and then came the order of 1991. And in the order of 1991, and I will read that to your lordships at a later point in time, the court said this has to be renewed for another 30 years. And as far as the central government is concerned, in 1968, it's already granted its approval for 30 years. So we don't have to go back to the central government. And they passed that order. In the meantime, the state government realized that there was a law in terms of which a lease could not be granted for more than 20 years. That's Section 8. 10 years, 10 years. So the court said, all right, we'll modify the order, but we'll modify only to this extent that the lease will still be 30 years. 20 years because the law says you can't have a lease deed for more than 20 years. But since the central government has already approved it in 1968, the other 10 years without anything more. They came to Supreme Court. When the matter was pending in Supreme Court, a compromise was entered into. And what was that compromise? State government said that you give up Thakurani A. You give up Thakurani A, we will grant you a lease for 30 years. Grant, Malads. They offered, Malads, they wrote a communication to us saying that if you agree to this, then only if you give up Thakurani A and you agree to the terms and conditions, we'll grant you Thakurani B for 30 years. We accepted that. We accepted that, Malads, in 1998. And on the 11th of February, 1999, a lease was granted to us. Not a lease deed. A lease was granted to us for 30 years. Pursuant to Malads, a compromise in terms of which the state of Orissa withdrew its appeal before the Supreme Court, and Malads entered into this compromise. Now, Malads, as your lordship knows, that within 6 months, the lease deed has to be executed. It was still not executed in next 6 months. So therefore, Malads, the 13th July 2001 letter was written saying that, look, it is true that the lease was not executed for 6 months, but we'll deem that period is extended. And ultimately, the lease was executed for a period of 20 years with the undertaking in terms of the compromise that there will be no break and that it will be automatically extended and we'll not have to file any application. That we will not have to file any application for extension of the lease. Now, Malads, what is important is my learned friend continues to harp on the concept of renewal. There is no renewal here. The further 10 years is an extension. The renewal is for 30 years. If it were a renewal, we would have to file an application in terms of the law and seek permission. But there is a court order, there is a court compromise, there is a solemn commitment. There is the act of the state of Orissa. You don't have to file another application. There is an imprimatur of the court. So this whole concept of renewal, that this amounts to a renewal, doesn't arise. Renewal already. This is not a 20 and a 10-year renewal. This is a 30-year lease, 1968, directed by the Union of India to be granted to us, which was not implemented. Then the law comes, 8A6, that if the period of the lease expires after 2015, then it will continue till the expiration of the lease. There is a difference between a lease deed and a lease. Section 3 of the Mines and Minerals Regulation Development Act talks of a mining lease, grant of a lease. That grant of a lease is on 11th of February 1999. And that is a grant. You cannot violate the grant. The state cannot violate its own grant. And that, your lordships will see, the definition of mining lease means a lease granted. The lease is not of in 2001. The lease is of 1999 February. In terms of Section 3, that's the lease granted. And if that lease expires in 30 years' time, my learned friend cannot use the law to say, because the law is in my favor and 8A6 is in my favor. So, I will take your lordships through all these documents. There is a confusion between the grant of another 10 years. There is no grant of another 10 years. This document itself. And TISCO case that my learned friend relies upon is a case where TISCO had two renewals of TISCO had already happened. And then 8.3 was resorted to, that if after 2 renewals happening, if you want a further renewal, you will have to then move and get approval of the central government. That's not the case here. It has no application here. So, I'll take your lordship through the facts and through the law. Broadly speaking, this is going to be my defense.
All right. Okay. So 2nd December, 3 o'clock.
Yes.
All right. All right. None appears. Right. None appears. In the interest of justice, you see, the note of the DR judicial agent perused. The counsel for the petitioner will be notified to remove the defects just after removal of defects.
Item 28. May I please, Lords? In this case, the petitioners, my lord, and this writ petition, my lord, rehabilitation of the street vendors under the Street Vendors Act, my lord.
No. So this is where we had asked you whether BMC council has been informed or not.
The name of the council is there, but my lord, in the noting, my lord, it was adjourned to 30th
Yes,
of
sir. Good
30th.
Good afternoon.
It was adjourned.
May I call item one, sir? Yes.
30th of November.
Item one.
But it is wrongly, my lord, listed today, my lord, I think. 30th of November already adjourned in the noting, my lord, the list.
Anyway, who's appearing?
Mr. Learned Council, Mr. Vibhudendra Das.
Both husbands, sir, and one Manish is joined, sir. Manish Kumar is there.
Anyway, you see list on 30th November, the date authorized.
Special weekly list.